relying on the expertise of the defendants.
There are no further questions. Thank you.
Okay, thank you.
Mr. Daniel.
So you said you have 2 witnesses. So since we're done with the examination in chief, cross-examination, and re-examination of the first witness, you can field your second witness now.
Good day, Mr. Chairman of Arbitrators and members of Arbitrator. We proceed to call our second witness, which is Mrs. Maria Adetula. We have before this tribunal a witness statement on oath of this same Mrs. Maria Adetula, which was filed on the 18th of July 2023. We would like to adopt this statement on oath.
Sorry, Tim Berry, we can't see this witness.
Sir?
We can't see your witness.
I believe that should be a connection problem. Mrs. Maria Adetula.
I can hear you.
Right.
Yeah, that is Mrs. Maria Adetula. So we would like to adopt the witness statement on oath of Mrs. Maria Adetula.
And then
Upon adopting, we would also like to tender Exhibit C3, C4, and Exhibit C5, which are the receipts for the payment of the construction, the picture of the stop work order received from the FCDA, and also a picture which shows that construction had gotten to the level of lintel on the land.
Please, can you state again the exhibit you tendered or you're tendering?
Exhibit C3, Exhibit C4, and Exhibit C5. Was I heard?
Yes, yes, you were. This is one of the documents. It says exhibit C3 is what? C4 and C5. Please, description of the documents.
With the adoption of the witness statement on oath, we have no further questions for the witness.
Moving to cross-examination. Can we just get description of the documents C3, C4, and C5 again, please? Descriptions of exhibit C3, C4, and C5.
Exhibit C3 is the receipt for the payment of the payment of 10 million naira made by Mrs. Emerson Klein to Maria Adetula Construction Company. While Exhibit C4 is a picture showing the stop work order received from the FCDA. Exhibit C4 is a picture of the stage which construction had gotten to, while Exhibit C5 is the picture of the stop work order received from the FCBN. I would like to state again for confirmation, Exhibit C3 is the receipt for the payment of 10 million naira received from Mrs. Emerson Klein, while Exhibit C4 is the picture showing the level at which construction had gotten to on the land, while Exhibit C5 is the picture showing the stop work order received from the FCBN.
Okay, thank you. We can then move to cross-examination. My point just happened in this place very fast.
Hello, can you hear me?
Yes, I can hear you.
Miss Maria, can you hear me?
I can hear you, sir.
Hello, I'm sorry, but I cannot see Miss Maria's face. I don't know. Miss Maria. Hello.
Yes.
I'm sorry, I can't see your face. I don't know. Okay, now it's better. Welcome, Miss Maria. Good afternoon.
My camera is on.
Okay, I can see you now. Miss Maria, can you hear me?
Yes, I can
Very
hear
well.
you.
Miss Maria,
Yes, I
by
can.
virtue of your profession, you're very knowledgeable in building construction. Am I correct?
Yes.
Very well. Miss Maria, before a building construction is commenced, building constructors first analyze and prepare sites, which takes about
We can't hear you well.
Can you hear me?
Yes, but the line is breaking somehow.
Oh, I'm so sorry. Is it now? Hello? Hello?
I think we can hear you now. Proceed, please.
Okay, but I don't know if the witness can hear me. She's not responding.
Okay, I can hear you now.
Okay. Thank you very much. Miss Maria, I asked that before, my first question was, by virtue of your profession, that you are very knowledgeable in building constructions, and you answered affirmative, yes. Okay, my second question is that before a building is commenced, or before the commencement of construction on a land, building constructors first analyze and prepare the site, which takes about 3 to 4 days. Am I correct?
No, you are not.
Okay, so there's no analyze, they don't analyze the site.
We analyze the site, but it doesn't take up to 3 days.
Okay, how many days does it take to analyze the site?
I can use a whole day or 2 days. It's just a
Very
plot
well.
of land.
Very well. Then the next stage, after analyzing the land, building constructors clear the sites. Am I correct?
Yes.
Clearing the site also takes about 2 days. Am I correct?
The site was cleared already.
Very well. And also, before commencement of the land, there's excavation of the land. Am I correct?
Excavation. There was no excavation on the land.
Very well. And there's also a foundation, the pouring of the concrete into the land for the foundation, which also takes about 2 to 3 days. Am I correct?
Yes, 2 days precisely.
Okay. Thank you very well. Then the foundation proper, which there's also the laying of the foundation proper, which also takes about how many days does it take, Ms. Maria?
I don't get your question.
I said the laying of the foundation proper, how many days does it take?
Foundation, everything, 4 days.
4 days.
Once
Okay,
the
very well.
resources
So
are
after laying
available,
of the
4 days is
foundation,
enough.
what next?
After laying
Very
of the
well, very well.
foundation,
After the laying of the very well, yes. What next, Ms. Aditula?
laying of blocks,
Which takes about how many days, Ms. Aditula?
4 days, depending on the structure. If it is a normal size, if it's not something so big, it will take.
Very well. Very well, Ms. Aditula. Ms. Aditula, last questions before I let you go, Ms. Aditula. I want to know, Ms. Aditula, a lintel being one of the major pillars in a building must be reinforced with concrete. Am I correct?
Yes.
Very well, Ms. Aditula. Thank you very much, Ms. Aditula. That will be all for cross-examination.
Thank you.
Like to discharge the witness and there's no examination.
Any re-examinations by the claimant, please?
Yes.
I take it that the claimants have closed their case.
Yes, we have.
Thank you. So the defendants can go ahead and open their case.
Okay, I just want to confirm if you can hear me. Can anyone hear me?
We can hear you.
Hear you.
We can hear you. You can go on.
Please, can anyone hear me?
We can hear you.
Yes, we can hear you.
I think Tinga might be having network issues.
Well, the defendants would love to open their case by calling on our first witness, Emmanuel. Local, please confirm if you can hear me.
I can hear you.
Okay, very well. Local, you made a written deposition in this matter. True or false?
True.
Well, what would you want this written deposition to be used for in this tribunal?
I want the tribunal to admit it as an evidence in this proceeding.
Well, we wish to tender the deposition as our evidence in this matter. Witness, in paragraph 3, you made mention of a deed of conveyance evidenced in writing. Also, in paragraph 7, you made mention of a plot allotment letter. Also, in paragraph 18, you made mention of a stage picture of the claimant's building. Also, in paragraph 29, paragraph 13 rather, you made mention of a notice that was pasted in the estate. What would you want this tribunal to do with these documents?
I want the tribunal to admit these documents as an evidence in this proceeding.
Well, we wish to tender these documents as exhibits in this suit, and we left the discretion at the hands of the tribunal to mark the particular exhibits. With that, we come to the close of our examination in chief for the first witness.
Defendants Counsel, please, can you hear me?
Yes, we can.
Good. The first document you tendered through your witness is deed of what? Deed of?
Oh, sorry.
Yes, deed of conveyance.
Deed of conveyance. The second one is what?
Plot allotment letter.
An allotment letter. I assume that's all you are tendering, or that's all your exhibiting.
No, we tendered 4.
Okay, please go ahead.
Documents.
First one, deed of
Third
conveyance.
is
second
yes.
Allotment letter. Third is what?
Deed of conveyance. A notice. Then the fourth.
A notice of what, please?
A notice that was pasted by the defendants.
Okay.
At the estate.
Okay.
Then the fourth is a picture showing the extent of work that the plaintiff in this suit has done on their land.
Okay. So for purpose of uniformity, I assume the claimant decided to go with C to mean claimant's exhibit. So would mark or would assign D's to your own exhibits. So let's do D1, D2, D3, and D4 in the same order in which they were tendered. So what that means is deed of conveyance is D1, allotment letter is D2, the notice pasted at the in front of the estate D3, then picture of work done That's D4.
Very well.
Are we together? Oh, good, great. So the claimants can then go ahead and can then proceed with their cross-examination.
Okay, just before they proceed,
Okay.
if I just state something, right? Did you read the procedural order that was issued and made available to you? Emanuela Otu, right?
Yes.
Counsel for the defendant, Tim Diamond.
Yes.
Did you receive the procedural order?
Yes, we did.
Right. You were instructed to mark your documents as annexures or exhibits, right? So not to leave it to us to mark, because in your concluding statement, you told us that you were leaving it at our discretion to mark the documents.
Yeah. I didn't understand that particular statement that way. I didn't. What was said in the procedure order was that we are expected to mark so I didn't know that we should actually do the marking. That's why we left it at the discretion of the tribunal.
Okay. Then even for the claimant, Ewaoluwa Amosu, right? And Rombi Abdurrashid. Are you there? Are you guys there?
Yes, sir.
Yeah, you when you were about to tender your documents, you mentioned that you marked your documents as exhibit C1 to C5, I suppose. But from the documents I have here, I'm not seeing any documents marked as exhibit C1 to C5, but you mentioned that you marked those documents. So are you assuming now that you are marking them from your oral statement as exhibit C1 to C5?
So what I can see is a lot of exhibits, exhibit C5, exhibit C5, exhibit C5, like about 5 of it. So there was an attempt to label, but they labeled all the exhibits as with the same title, C5, without specifying which is which. That's for the claimant now.
I do, because the documents I have with me, I just wanted to confirm. The documents I have with me, they were not marked, right? So, don't know. Okay, so let's assume that they made an attempt to mark the documents, but the ones I have were not marked. And Chairman, the ones you have with you, were they marked?
Yeah, equally not marked.
Okay.
Equally not marked.
And then again, counsel to the defendants, did you front load all the documents that you just tendered? The deed of conveyance, the allotment letter, notice pasted by the defendants, and then the pictures.
I didn't get your question.
Did you send across to us the documents that you just tendered?
Yes, we concluded everything. Everything is together in our process.
Okay. Because again, I can see allotment letter, I can see deed of conveyance, I can see the public notice, but I can't see any photograph. I don't know if it's from my own end or if my co-arbitrators have experienced the same issue. I can see 3 of the documents you tendered, but there's no picture. It was the claimant that tendered photographs, was photograph of the stop work order and then photographs of the building.
We sent the picture, but it was not in the process. We sent the picture as a separate.
Okay, no problem. So probably there was a mix-up somewhere. Let's assume that you sent them. Maybe we somehow mixed with the claimant's process, and that was why you should have marked your exhibits so that we don't mix them. If you had marked them, we would have been able to see that these particular documents were concluded by the defendants, right? Okay, no problems. Proceed.
Please, I want to confirm. Simpel. Hello, Simpel. You said you. So okay. I think someone wanted to say something.
Yes, please. I wanted to ask the claimant had given us a list of documents they tendered. So I noticed you didn't only file file a PO. We also received a document this morning that I don't think was accounted for. Anyways, just give us, the defendant should give us a list of document that they tendered, please.
No, that's for round 2. I think the people that filed this morning.
Okay. Since the claimant has given us a list of documents that they filed and the dates they filed, can the defendants just quickly do same as they didn't do that in their opening address when we asked them to? Or not the documents you seek to rely on, just the process file. Can the defendants hear me?
Yes, we can.
Very good. Just quickly tell me the documents that you filed, real quick.
Okay. We filed a deed of conveyance.
No. Process is filed, not documents you seek to rely on. We've already marked your 4 documents. You filed a statement of defense. Is that all you filed?
Okay, a statement of defense. No, a statement of defense. And 2 witness statement on oath for our 2 witnesses. And our written address. Okay. Yes. A statement of defense, 2 witness statement on oath, and our written address.
All filed on the same day.
Yes, it was all together in one document. It was only the picture that was sent as a
what date was that? What date was that?
Dates.
Yes, please.
21st of July.
Thank you. Okay. We can proceed now. Okay, the claimants can if except my co-arbitrators want to ask any further questions, the claimants can then go ahead with their cross-examination.
Yeah,
I have no questions. Claimants can proceed, please.
Thank you, sir. Mr. Emmanuel Okoro, are you there? Mr. Emmanuel Okoro. Mr. Emmanuel Okoro.
Mr. Emmanuel Okoro is here, please. I'm here.
You are here?
Yes.
Okay. Mr. Emmanuel Okoro, in your witness statement on oath, you stated that the claimant did not inform you of the purpose for which she required the land. Is that true?
Come again, please. Can I hear that question again?
So sorry about the glitch. Mr. Emmanuel Okoro, are you still there?
Yes, I'm here.
So I said you stated in paragraph 5 of your statement of oath on oath that the claimant never informed your company the purpose for which you require the land.
If I get it correctly, what we did what was especially stated there. What we mean there is that the purpose we conveyed. It was explained to the complainants the general purpose and the general uses that the land could be used for. But then
Mr. Emmanuel Okoro, the question I asked was, did the claimant inform your company that she needed the land for commercial art?
No.
No. Okay. Now, you tendered a plot allocation letter, right?
Yes.
In the plot allocation letter, what does the opening statement in the letter reads, having paid a purchase price of 5 million naira, Matrix Properties Limited is pleased to allot you plot number 2437-34 for commercial development. May I humbly bring the attention of the honorable members of the tribunal to this particular paragraph in the allotment letter.
Now, I will need you to understand. Excuse me. Can you hear me?
Yes, we can hear you.
In that witness deposition, it is stated there that the general purpose for the land, which include residential and commercial, that is what was conveyed from the advertisement period. And so adopting one of them.
My question now is, why was it not in the plot allotment letter? There was no mention of residential activities in the plot allotment letter. The only thing mentioned specifically was commercial development. If the claimant didn't inform your company the purpose, how did you now mention only commercial development in the plot allotment letter?
Because by the time we entered into by the time we were telling the complainants about the land, a commercial purpose and residential purpose, both of them. That's what we talk about both of them, and so either of them.
Okay, either of them, but residential purpose was not mentioned. So I'll proceed to my next question. In the same plot allotment letter, when the conditions subject to which the land was allotted, there's a discrepancy, there's a disorder in the alphabetical order of the conditions. The first one is A and the second one is D. Can you provide an explanation for that?
I'm not hearing you right now, and please, sorry, your statement got somewhere along the way. The question you asked, I didn't get it fully.
In the plot allotment letter,
okay,
there is a disorder in the alphabetical arrangement of the terms and conditions. The first one starts with A, and the second one starts with D. Is labeled D. What happened?
Okay.
Are there some conditions you have adopted or removed from the plot allotment letter?
You need to understand that when we put things in writing, there could be some typographical errors.
Oh, are you aware that the honorable members of tribunal, May I humbly refer to the plot allotment letter tendered by the claimants? It will be noticed that this plot allotment letter is the same, only for the fact that two conditions have been removed in the defendant's version of the plot allotment letter. So I'll proceed with my next question. So you tendered a public notice.
Excuse me. You talked about, you mentioned two conditions, right?
Yes.
Those two conditions you're talking about.
You said your company made a public notice out to the public, to the people of Sunrise Estate. Is that right?
Yes, that's right.
And you tendered a copy of the public notice.
That's correct.
Yes. Now, this public notice, how does it show that this notice was actually posted? Is there anything in this notice that shows that it was actually posted?
It was actually posted, and that is why that notice is. That's the purpose for that notice. That's what this notice is serving.
The claimants did not see the notice, and there is you don't have any evidence to prove to us that anybody saw it or that it was actually posted. Honorable member of the tribunal,
it was posted. It was posted on a notice board.
Hello?
So having posted it.
Yes, sir.
Okay, so I'm not supposed to rein in at this point, but just so that there is no back and forth. You are aware that you're not testifying, right? You're only asking questions. So can you just restrict yourself to the question so that we don't go, the more you testify, the more you do this back and forth with the witness, right? So that we can save time.
Okay, sir.
Just asking questions, and please just answer questions, the witness.
Okay, sir. So, Mr. Okoro, there is nothing to show. You don't have anything to show. You don't have anything to show to us that this notice was posted, right?
The notice was posted on a notice board. Having posted it at the right place we've done our duty, and so.
Okay. Your company went through the audit to go and snap the land and tender it as the land of the. Okay, let me just move on.
It's as regards to snapping the land, which you just mentioned, we do carry out a routine check once a week. And when we carry out this routine check, one of the things we do is to take pictures of developments that are going on in the estates. And so the last time, that picture you're seeing there, that was the last time we did a routine check, and then we saw that development at that level, and then we took the picture of it.
What I'm saying is, why did you not snap the picture of the billboard on which this notice was posted? Honorable member of the tribunal, if this notice is of any evidential value, it's only evidence of the fact that this document was typed.
Sorry.
Not that it was actually posted.
Excuse me, why did I not snap which picture?
Sorry to intervene again, Mr. Abdurrashid, right? Mr. Abdurrashid, can you hear me?
Yes, sir.
Yes, you've been cautioned earlier that this is not addressed. There are certain things you are making clear now that you're supposed to leave for address. You're supposed to just ask the witness questions and let the witness answer. You don't draw the attention of the tribunal to anything. You can do that during your address, right? So that you don't waste your time and our time.
As the arbitration pleases.
Hello, sir. No, sir. Yes, sir. Can anyone hear me?
Yes, can hear you.
So I had a glitch.
Can you speak louder? You can barely hear you.
I said I had a glitch. I didn't hear what you said. Hello, sir.
So the my co-arbitrator was simply saying that you should go ahead and ask questions and leave issues that are supposed to be in your address for address. Do not, the idea of cross-examination is not for you to draw conclusions, it's just to ask the witness questions. Whatever inference you intend to draw from those answers, you can establish that in your address, and then save the time and save your time and our time. Hope you heard me now. Hello.
Hi, sir.
Good.
No further questions.
Any re-examination?
Yes, we
Yes, please.
Yes, please.
The safe statement allotment. Is it safe to say that ordinary trade custom?
Exactly. It is just an ordinary trade custom because we owe it as a duty to educate the person who has come to purchase a piece of property. We have the presumption that the person is buying it for the first time. Like we educate the person basically.
And it is also safe to say that it's not specifically tailored toward the claimant.
Yes, it's not specifically tailored toward the claimant because yes, it's not specifically tailored toward the claimant.
Is it also safe to say that the saved notice was pasted at the only entrance in the estate?
Yes, it was pasted at the only entrance of the estate.
Can you confidently then say that every person going in and out of the estate must see that notice?
Exactly, that's the absolute truth. Thank you.
Okay. Can all parties hear me, please? If you can hear me, just okay, good. I can see some Emmanuel to taking off his so I assume you can hear me. So you have a second witness. I think we're done with this first one. Can we go ahead and take your second witness?
Okay. So
I can hear you. Did you make any? Yes. Sorry, I didn't get that. So, did you make any written deposition in this proceeding? Sorry, I didn't get. So, did you make any? Yes, I did. What would you want district tribunal to? I want this tribunal to adopt it as evidence in this case. So we wish to tender written deposition as second witness evidence in this case. That will be all for this week. That will be all for.
Please, can we see the second witness? Can see the second witness, please?
Can you see her now?
I'm sorry, there was a glitch. Can you please repeat what you said?
Can we see the second witness before the claimant commences with their cross-examination?
I'm present.
The video is off. I can't see anybody.
Can you see her now?
Maybe it's from my end. Can any of the co-arbitrators confirm if they can see the witness?
I can't see anybody as well.
I still
I
cannot.
also can see.
We would have decided to continue, but seeing that this is an online medium, and part of the principles usually in holding an ODR session is that the witness should be seen, and to ensure that the witness is not being told what to say or prepped or led in any way. So it will be important that we see the witness, and the witness will be visible while questions are being thrown at the witness and the witness answers.
The witness is present.
Yeah, if witness is present, we just cannot see the witness.
Is play an issue with your internet? Do you have any alternatives I can use there?
Because I can see the notification that your bandwidth is low. Well, in the circumstance, if both parties agree that the tribunal should proceed, we can proceed with the video being off. But if the other party doesn't agree, then we'll have to wait till the video comes on.
So the claimants, do you consent to us proceeding without seeing the witness?
No.
Okay.
Can you see me now? Can you see me now?
We still can see you.
Can you see me now, please?
Yes, we can. Yes, we can.
All right.
Okay, we can see her. So the claimants can proceed with their cross-examination. We can see the witness.
Witness, you claim to be the General Counsel of the FCDA. Is that right?
Yes. Yes, I am.
How long have you been working for the FCDA?
I've been working for the FCDA for 10 years now.
Okay. So in your witness statement on oath,
yes,
you claimed that the FCD in paragraph 7 that the FCDA acknowledges the oversight and is working towards compensating the affected parties. What are the steps that the FCDA has taken so far?
Yes. Currently, the FCDA is having talks with the government of the Federal Capital Territory to know how we can compensate the affected parties, because the purchasers of these properties involved, it's not just Emerson. There are actually lots of other purchasers. So we are in talks with government on how to compensate all of these parties as a whole.
As of this moment, has the FCDA released any notice to the parties or make any attempt to get in touch with the affected parties? Yes or no?
Yes, we have. Yes, we have done that.
How?
We have just notified these parties that we are in talks with the government to compensate them.
Very good. For at this moment, you have not compensated anybody.
We have not compensated anybody, but we are in talks with the government currently.
Yeah, that's very good. No further questions.
Okay, thank you very much.
Any re-examinations?
Yes. Can you hear me?
Yes, I can. Yes, I can hear you.
Did you communicate information as regarding the plans of the government, of working towards compensating the affected parties to MPL?
Yes, I did. Yes, in fact, on the 28th of July, the managing director of the MPO came to my office. He was actually quite upset about it. And I explained everything to him, that we are currently in talks with the government, and the government, obviously, we have plans to compensate all of the parties involved.
Is MPL the only estate, sunrise estate owned by MPL? The only affected estate?
No, not at all. Of course, there are a lot of other purchasers of different properties that were affected by this.
In your estimation, how many months do you feel the government can actually take to?
Excuse me, please. Is this fresh examination or re-examination? I need to be clear as to that.
It's re-examination. The issue came up during the course examination.
Okay, so maybe I should not be the one to object, but this is arbitration this arbitration, so I mean, the panel can interject from time to time, right? And this is actually not a re-examination, right? You are giving fresh evidence.
Very well, Mr. Advocate. That would be all for the examination.
Thank you.
The defendant has called attendant all not
Okay. Can all the parties hear me, please? Can the parties hear me?
Yes, we can hear you, sir.
Good. So at this point, I think we've come to the close of taking witnesses. I know you have your closing addresses. So it's time for you to address the tribunal.
So, sir, who is to go first, sir, the claimant or the defendant? We are expecting that.
I don't. So I don't want to be a stickler for the procedure of the defendant going first or the claimant going first. To say who led evidence / should go first. In subject to what my co-arbitrators think, Mr. Kigai and Mr. Chimeze, I would think the claimant should go first. I would prefer that procedure, but if we want to stick to the normal, practice of the defendant going first, that's equally fine. So I would leave this to my learned brothers to also agree on what procedure we should follow.
I have no objection to that procedure at all. It's fine.
Oh, great.
None for me also. We can proceed as you have suggested.
Great. So the claimant will go first. So claimants give us a closing address, and then the defendants will follow suit.
So before we proceed, claimant, did you file a post-hearing brief? Did you file a written address?
No. At the preliminary hearing, the conclusion was that we were not to file any post-hearing brief. So we were even shocked to receive a written address from the defendant.
Sorry, I can't quite hear you.
I said that at the preliminary hearing, the conclusion and the agreement was that no post-hearing briefs will be filed, that only oral submissions will be made. So we were surprised to receive the written address from the defendant. But if the arbitrators require it, the honorable members require it, it's available.
Okay, so that's fine. Address us orally then.
Good day, member. Good day, honorable members of the tribunal. I am Abdurrashid once again, as earlier announced. And I shall be delivering the final address of the claimants alongside my co-counsel, Ewaoliwa Amusu. The claimant has distilled two issues for determination. Issue one is whether the defendant is in breach of the condition of the contract between the defendant and claimant, while issue two is whether the claimant is entitled to a refund of the purchase price and the damages claim. I shall be addressing the tribunal on the merit of the one in the next 6 minutes, while my co-counsel shall be addressing the tribunal on the merit of issue two.
Please repeat the issue two that you raised again. Sorry.
Whether
could you please repeat your issue two?
The issue two is whether the claimant is entitled to a refund of the purchase price and the damages claimed.
Okay, thank you.
So I shall proceed with on the merits of this one. On issue one, which is whether the defendant is in breach of the condition of the contract between the defendant and the claimant contends that the defendant is in breach of the condition when it stated that the land could be used for commercial development, but it turned out that the land could not be used for commercial development. A condition has been defined by the Supreme Court in Federal Government of Nigeria versus Zebra Energy as a term which entitles a party in the contract to resign the contract. The contention of the claimant is based on the ground that the statement of the defendant that the land could be used for commercial development constituted the term of the contract. A contractual term is any provision which form part of the contract. It is a promise as to the truth of any statement. While it is true that this statement of the defendant was made pre-contractual, this does not affect the status of this statement of being a term of the contract and not a mere representation, because it is a tried principle of law of contract that whether a contractual statement constitutes a term of the contract or a mere representation is a matter of construction, which depends on the circumstances of the case, the intention of the parties, and the importance attached to the statement. Accordingly, certain criteria have been developed over the years to determine the nature of the contractual statement. One of these criteria is one party's superior knowledge, where the party who made the statement has superior knowledge compared to the other party. Such statement is taken to be a term of the contract. I will refer the tribunal to the case of Eshore Petroleum Limited and Maldon. In this instant case, members of tribunal, there is no doubt that the defendant has superior knowledge compared to the claimant, being the developer of the estate. So the statement that the land should be used for commercial development constituted a term of the contract. Another test, which is also used by court to determine the nature of the contractual statement, is the importance attached to the statement by the party who alleges that the term is a term of the contract, where that party can show or demonstrate that he would not have entered into that contract, but for the assurance for that statement, such statements will be taken to be a term of the contract. I only refer this tribunal to the case of Bannerman and White and 1861 10 CBNS 844. In this case, the position of the claimant is very obvious. He would not have entered into this contract, but for the assurance that the land will be used for commercial development. The claimant informed the defendant that she wanted the land for a bakery business, for an act which is a commercial activity. This is very obvious in Exhibit C2 of the claimant, which is the allocation letter sent to the claimant by the defendant. The opening statement states that the land being allotted to the defendant, the claimant, was for commercial development. The defendant would not have put that in the allotment letter if they had no awareness of the purchase of the purpose for which the claimant required the land. It is so obvious. And also, even though the defendant tried to remove it in their own version of the allocation letter, the statement is very obvious. The disorder in the alphabetical arrangement of the conditions, which is very similar to, which is the same with the one in the Exhibit C2 of the claimant's allocation letter, or the C2 of the claimant. This disorder shows that some of the conditions that have been doctored have been removed. The alphabetical disorder is evidence of this. Furthermore, the reduction of a statement into writing in any letter document executed in contract is another test that is used to determine whether a contractual statement constitutes a term of the contract. Where the statement, oral statement, is reduced into any writing or document which is later executed in the contract, such statement is taken to be a term of the contract. And when there is a breach of such statements, the implication is that the defendant, the party who breaches that statement, the condition, the term, is liable for breach of contract, breach of condition of the contract. In this case, the statement was reduced into writing, which is the plot allocation letter. It is there in both the version of the plot allocation letter of the claimant and that of the defendant, that the land was allocated for commercial development. Having established that this statement constitutes the term of the contract, it is without doubt that the statement was the condition of the contract, as it goes to the root of the contract, which is the major purpose for which the contract was executed. Based on this argument, the claimant submits that the defendant breached a condition of the contract between the defendant and the claimant. I shall now defer to my co-counsel to argue on the merits of issue 2.
All questions to you. The second issue is whether the claimant is entitled to a refund and damages for the losses incurred. The claimant contends that she is entitled to a refund of 5 million naira, which is the purchase price of the plot of land in Sunrise Estate. This is premised on two conditions, namely that the defendants breached a condition of the contract and that the statement was a misrepresentation. Elaborating on the first premise, which states that defendants breached a condition, based on the points canvassed by my co-counsel in issue 1, it has already been established that the defendants breached a condition of the contract, which stated that the land could be used for commercial activities or for commercial development. It is a basic principle in contracts that where a party breaches a condition of the contract, the other party is entitled to repudiate the contract if he or she so wishes, and also entitled to remedy for any loss incurred. This was reiterated by the Supreme Court in case of Federal Government of Nigeria versus Zebra Energy Limited. In this case, the defendants clearly breached a condition of the contract, which stated that the land could be used for commercial development, which is such a basic term that it was what the contract was anchored upon. Therefore, the claimant contends that she is entitled to a refund of 5 million naira, which was the consideration for that contract, the purchase price for the plot of land. Moving on to the second premise, we state that the statement itself was a misrepresentation. The claimant contends that, assuming but not conceding to the fact that the statement was not a term of the contract or a condition, but was instead a representation, she's still entitled to remedy in form of an award for damages, rescission of the contract, as well as indemnity. The term misrepresentation was defined in the case of Duro YA versus UBN PLC by the Supreme Court, where it was stated that a misrepresentation is a false or misleading statement about something. It is a statement so made on an assertion which are not based on fact. So for the burden of proving misrepresentation lies on the party who alleges it. The Supreme Court, in deciding in the case of Olaogun and others versus Benson Limited, stated the criteria or the elements needed to be able to establish misrepresentation in any case, being that the representation must be material and unambiguous, The representation must be a statement of fact existing at the time, and the representation must be one that was relied upon by the claimant in the case in order to enter into the contract. I would like to elaborate on this element and prove that these elements do exist in this case. For the first element, we state that the representation was a statement of fact existing at the time. I believe that it has already been established that the statements made by the defendant in this case was established as a statement of fact. On the basis of materiality, which is the second element, the test is to prove that the representation will have influenced the judgment of any reasonable man and induced him into entering the contract. In this case, the defendant's statement of the land being used for commercial purposes was what induced the claimant to enter into the contract, being that it has earlier stated in paragraph 1 of the fact that the claimant intended to use the plot of land to establish a bakery, being that she intended to use it for commercial purposes. The fact that the land could be used for commercial development was essential to this contract and as well as material, being that it was a clear statement that was stated in the contract of sale as well as reiterated in the plot allocation letter. It can be said that this statement was not unambiguous. It was clear and concise. The claimant also stated that another important element is that the representation was relied upon by the claimant in this case. The claimant's subsequent purchase of the land for a price of 5 million naira, as well as the land with the construction company in order to build of the land to establish a bakery, and the payment of a sum of 10 million naira, which was the initial payment of a 15,000 naira of a 15 million naira payment for the development of this building, are proof that the claimant relied on this representation in order to effectively enter into the contract. The law is that when a person is induced to enter into a contract on the basis of a misrepresentation, the representee is entitled to remedy, being namely rescission of the contract and indemnity. The defendants might claim that they made this statement in error, and while that may be true, it based in error on the outdated zoning regulations, which were improperly communicated to them on the basis of the certificate of occupancy. However, it must be noted that despite this error, the statement was still a misrepresentation, and it still induced the claimant to enter into a contract of sale for the purchase of the land with the defendants. Therefore, this only makes it an innocent misrepresentation at best. Even if it is an innocent misrepresentation, and it's established in the case of Dick Bentley versus Harold Motors, it is still, the claimant is still entitled to remedy. It's still entitled to remedy in the form of award for damages, a refund, and a rescission of the contract should he or she wish. Based on the foregoing, the claimant submits that she is entitled to a refund of 5 million naira as well as damages for the losses she has incurred in terms of the money spent, the time, as well as the continual cost being constantly expended because of the holding cost of keeping the building where it is and stopping all the development on it. Based on all the arguments canvassed, with legal and judicial authorities agree, the claimant seeks that the tribunal resolve all issues in favor of the claimant, as well as an award for the refund of the purchase price of 5 million naira, an award for the damages, an award for the refund of 5 million naira, which was the purchase price of the plot of land, damages in the sum of 12 million naira for the money spent, the time, the efforts spent on the construction of the building ever since the contract was concluded, as well as a sum of 500,000 naira, which will cover the legal cost of pursuing this matter, as stated based on the arbitration clause, which was included in the application letter. Thank you.
Okay, the defendants. Thank you, claimant. Tribunal has heard your address. Can we move to the claimant? Can we move to the defendant, please?
Thank you very much. Can you hear me?
We can hear you.
Thank you very much. Honorable Tribunal, defendants in their written address raised two major issues for consideration, which are one, whether defendants in breach of a vital condition.
I can't hear the defendants. Can anyone hear them?
Can you hear me?
Now I can hear you.
Okay, thank you very much. Okay, I stated that the defendants in the written address, which we filed before this honorable tribunal, the defendants raised two major issues for determination for consideration by this tribunal, which are whether the defendant is in breach of the vital condition of the agreement, and two, whether the defendant is liable to refund the purchase price of the land and to compensate the plaintiff. I will be addressing this honorable tribunal on the first issue for consideration, and my co-counsel will be addressing the tribunal on the second issue for determination. On the first issue, a vital condition, which is a term of an agreement or a contract, is an important term of the contract. And where there's a breach, the innocent party can ask for repudiation and damages. But where an agreement has been put down in writing, the terms of the agreement must be gotten from the written agreement, and oral evidence or other evidence will not be used to interpret the written agreement. Before this tribunal today, the defendant tendered the deed of conveyance and the allotment letter, which was tendered before this tribunal. And nowhere in these two documents show that there was a vital condition as to the purpose of the land being for commercial purposes. Also, defendant witness, the managing director of the MPL, Emmanuel Okoro, gave oral testimony before this honorable court that the purpose of the land being for commercial development was not stated as a term in any of the agreements, and did not form a major part of the agreement between claimant and the defendant. The witness of the claimant, Emerson Klein, who is also the claimant in this, in her oral testimony, when she was asked during cross-examination, the counsel to the defendant asked Emerson Klein that so a lawyer must have assisted you in the land agreement you entered into on 10th of March 2023. Am I correct? And she answered yes. But in her written deposition before this honorable tribunal, in paragraph 2, she stated that the agreement was entered into on the 10th of May. This is a different and totally unrelated with the 10th of March, which she answered affirmative. So members of the tribunal, this is a discrepancy. And the testimony of this particular witness cannot be used to determine this particular issue. The witness, in her written deposition, stated that she informed the claimant of the purpose of the land that she bought. But this honorable tribunal can see that her testimony cannot be used as credible evidence to adjudicate on this particular issue. Also, even if the purpose of the land agreement was a vital condition to the agreement between the claimant and the defendants. The award which the claimant is seeking for is way overboard. Honorable Tribunal, during the cross-examination of the second witness of the claimant, Ms. Maria Adetola, she claimed to be very knowledgeable in building construction, and she claimed to be the building, the constructor of the land of the building which the claimants claim have gone up to lintel level. But before this Honorable Tribunal, during cross-examination, she was asked if a lintel being a major pillar of the building must be reinforced with concrete, and she answered in the affirmative. But a lintel is not a major pillar, and is not any of the is not a pillar at all in a building. A lintel is something totally different. It is what is above the door. Members of this Honorable Tribunal, it is clear that Ms. Maria Adetola is not a building constructor and is not in any way connected to this particular issue. Honorable Tribunal, the claimants are only seeking this release to rip off the defendants, and the awards that were sought by the claimants should not be awarded. So I just Honorable Tribunal to refer to my co-counsel, Manuel.
To address issue 2, which is whether or not the defendant is liable to refund the purchase price and to compensate the plaintiff. Now, my co-counsel has canvassed arguments on how indeed the said term which the claimants claim was a fundamental term was not actually a fundamental term in the contract. Now, assuming without conceding that this term was actually a fundamental term, defendants would come through the angle of the doctrine of frustration. Now, the defendants have already front-loaded arguments and cases on this issue, but I would love to highlight a few cases. Now, in the case of Dauda versus Lagos Building Investment Co. Limited and others, the court was clear that the doctrine of frustration occurs when, after the contract is formed, a supervening event occurs that renders performance of the obligations of both parties impossible or illegal. Now, bringing this to the case at hand, looking at paragraph 11 of the statement of claim of the claimant and also the statement of defense, both parties in this suit are agreed on the fact that there was actually a stop work order, and this stop work order operates as a supervening event because it left the both parties handicapped. It's rendered performance of the obligation involved in this contract impossible and illegal, and there is no way that any of the parties would have gone further to do anything as regards this contract. Now, moving forward, in the case of Access Savings and Loan PLC versus WIWA, the court stated that for frustration to occur, the supervening event must have occurred without fault of either parties. Now, through our witness statement on oath and all we've tendered today, it is clear that this stop work order was not the fault of the defendants in this suit. In fact, the claimants are even agreed with us that actually this stop work order was by the FCDA. And in fact, it was a result of the mistake of the government and not the defendants. And so defendants should not be made to bear the loss of a mistake of the government, because this would be heavily unjust on defendants. In fact, the defendants are also a victim in this matter, and it will be quite unjust to make them to bear all these losses for a wrong that they have no fault or no part in. Going further, frustration occurs from the occurrence of an intervening event or change of circumstance so fundamental as to be regarded by law, both as striking at the root of the agreement and being entirely beyond contemplation of parties when the agreement was entered into. Now, looking at the deed of conveyance and the plot allotment letter tendered, this particular risk of the stop work order was not contemplated by either of the parties. In fact, they entered this contract, both parties agreeing that everything was okay. Now, for the fact that this event happened, it's a supervening event, and the effect of a supervening event occurring is that both parties will be discharged for all liabilities and obligations in the contracts. Now, it is the position of the claimant that defendants breached a fundamental term in the contract. In fact, their whole case is hinged on the fact that it was a fundamental term that was breached by the defendant. Now, from our witnesses and the evidence we've been able to abuse, both the deed of conveyance and plot allotment letter, we've been able to show that, in fact, this was not a fundamental term. And the statement that was pointed out by the claimant in his course examination, that statement was not tailored particularly to the claimant. It's an ordinary trade custom. In fact, that is a template that is used by the defendant in any plot allotment letter they would want to. It's an ordinary trade custom to make such statements. So it was never agreed by the defendant and claimant that that's in fact a fundamental term in which they base their contracts on. Now, to bring all these witnesses into context. Now, the first witness of the claimant, he came to state that it was actually a fundamental term, but we've been able to puncture this by adducing our deed of conveyance and our plot allotment letter, which emanated from us, which we gave them, and it shows that, in fact, this was not a fundamental term in this contract. The first witness of the claimant also agreed with us that the stop work order was caused by was as a result of the mistake of the FCDA. And in line with this, we are saying that because of this stop work order was a frustrating and supervening event, the defendant should not be held liable for the loss, the fact that they lintel stage. Now, simple question, prove this fact. Now, 3 weeks is not enough to reach lintel stage. This is a common knowledge. 3 weeks is not enough to reach that stage that they claimed in their petition. Now, this goes to show that the claimant actually instituted this matter just to rip defendants off. In fact, they claim that they said this, that they brought this proceeding before the tribunal as a representative action. But yes, in the awards, the awards that they claim, they are only claiming damages and refund of purchase price for themselves. Now, for a case to be a representative action, it should go down to the awards that they claim, but they claim it for themselves. This goes to show that they instituted this, they brought this proceeding before the tribunal to rip the defendants off. They saw it as an avenue to rip the defendants. Now, for our witnesses, our first witness actually proved the issue that this was not a fundamental term. Our first witness proved that this the stop work order was actually a frustrating event. A second witness also came to state that she actually met with our first witness, which is the managing director, and they've been in talks. And she also stated that MPL is not the only affected estates. There are a lot of estates affected. As such, this will take some time for this issue happened like a month ago. Now, it's very obvious that this will take some time to be rectified. Now, for the defendants to rush and institute this matter in the arbitral tribunal, seeking for these damages for themselves alone, shows that they intend to use this opportunity to actually rip the defendants off. Now, based on all these arguments that we have canvassed, we actually seek this arbitral tribunal to hold that the defendant should not be held liable to refund the purchase price and damages. And in fact, it would be quite unjust to step in and shift the blame to the defendant solely when it is clear that the event happened as a result of the mistake of the FCD, and in fact was a frustrating event that handicapped the defendant. And in fact, the defendant actually made efforts to rectify it, but still it has proved not actually working. But then the government has actually promised to do something. So it would be better for the claimant and defendants to join hands to actually move towards the government and not the claimants moving at the defendants. With all these issues based, all the evidence we've tendered, and all our witnesses have come to say today, we seek the tribunal to resolve these issues in our favor and refuse to grant the award sought by the claimants. Thank you.
Thank you to both teams. Thank you to both teams. With this, we've come to the end of the first stage. Subject to my co-arbitrators, it will be time for us to move to the second stage. But I leave the floor for my co-arbitrators to give their comments before we move on.
Comments as to the merits or substance of the case, right? So I see that the participants for the second round are online as well, right? So if I should seek the direction of the moderator, right? Do you think that we should make general comments after each round or after the entire round? But I said, I'm not sure it would be proper to make any comment at this point, right?
Yes.
Please
yes,
clarify.
After the round, so that's the other team will not pick one.
Exactly. I thought that much. Yes.
Yeah. Okay. Marisaki guy, any comments?
Yes, so I agree with the point made by Chimezi. I think we'll proceed to the second round so that afterwards we can make our comments generally or to this team specifically.
Okay, thank you. Barrister Daniel, do you want to say something?
No, that was also my take. So I already had this conversation earlier with one of the co-arbitrators, and he felt the same way, because explaining or giving a debrief or trying to analyze what happened in this case might not even help the other parties. Might go a long way in confusing them in presenting their case, because we're trying to adjust and make fixes here and there. So it's better everybody goes ahead.
Okay, that's fine. So for the second round, HJIUF NMCC 2-2023, we have Mr. Nyola represented by Timpel and Mr. Ademola Oladeji represented by Team Emerald. And for this round, we have Barrister Chimezi as the arbitrator for Team Emerald, while we have Barrister Daniel for Timpel, and the head of this arbitral panel, it's Barrister Kigai Zotom. So we can proceed. Barrister Kigai, over to you.
Okay, so gentlemen, good afternoon. We have spent quite an amount of time on the first team. So I believe because these teams have been part of the proceeding from the beginning, there will be less house cleaning to do and we'll get straight to business. So I'll call on the claimants. The claimants here is, what's the name of the team again? So,
Timpel.
Timpel of the claimants. Okay. So Timpel, you will make your opening statements, of course, announce your appearance, make your identify the processes that you have filed. By the processes, I'm sure you've gotten by now. I'm saying, for instance, have you filed your statement of claim? Have you filed your reply? Is there a response to a PO or any document that you have filed? You identify those and the dates that they have filed. Then you proceed to make your opening statement, which should be within the timeline that we have given. The defendant's team will do the same when it's their own time, and then we immediately proceed to calling up the witnesses, and let's see how best we can make of our time. Is that okay?
Yes,
Simple.
sir.
Okay.
Yes, sir, it's fine.
All right, so can we proceed?
Good day, Mr. Arbitrator. Appearing before this arbitral panel is O.D. Ebiremu, and with me is my co-counsel before this arbitral panel, A.O. Ade Akin Bami. Mr. Arbitrator, we have filed a notice of arbitration dated the 18th day of July 2023, and we've also filed alongside a statement of claim, a 9-paragraph statement of claim dated the 18th day of July, also 2023. Also, Mr. Arbitrator, we also filed a written address dated and filed 18th of July 2023. Mr. Arbitrator, also we filed witness statement on oath in line with the rules of this arbitration on the 19th of July 2023 alongside our exhibits. Mr. Arbitrator, also we filed a reply to the preliminary objection raised by the defendant's counsels on the 25th of July 2023, and also we filed a reply to their processes, the defendant processes, on the 25th day of July 2023. We beg to submit, Mr. Arbitrator, in the case before this arbitral tribunal is between Mr. Eniola, who is the claimant, and Mr. Adewale, who is the defendant. Mr. Arbitrator, the case is about a disputed land at number 12 Peshway, Ugbawa, Lagos State. Okay, and Mr. Arbitrator, the land dispute, which will prove subsequently, belongs to Mr. Eniola. However, Mr. Arbitrator, Mr. Adewale falsely claims ownership of this land, of this disputed land, which in fact belongs to the claimant, Mr. Eniola. Mr. Arbitrator, our purpose of appearing before this arbitral tribunal is to prove that the claimant is indeed the registered owner of the disputed land, and whence the claimant seeks the following reliefs: that a declaration that the claimant is the rightful owner of the disputed land, and 2, an order for the defendant to vacate the disputed land and with all its belongings, and 3, an order for the defendant to pay the claimant damages for the trespass and unlawful occupation of the disputed land. The claimant claims damages of 1 million naira. Mr. Arbitrator, we beg to submit. This is all for the opening address.
All right, thank you, Tim Emerald.
All right, please, can you hear us?
Yes, you can.
All right, thank you so much. The respondent in this suit is Mr. Adewale, and for our opening statement, Mr. Adewale is the owner of a disputed land, particularly number 12 Pashwe, Pella, Ebowe, Lagos State. And this particular land, he has been in possession of this land for decades.
Please hold on. Announce your appearance so that we can take notes, then you can proceed. Right, let's note your names and who's appearing with you.
Thank you so much. All right. I am Chisum Darlington, Madubike Chisum Darlington, Esquire. Appearing with me is Igwenyere Harrison. Igwenyere Harrison. We both are representing the respondent. Can I go?
Yes, please proceed.
Thank you so much. All right. The disputed land, one that has been in possession of the defendant for some years now, over 2 decades. And the claimant got to obtain his land in 2005 from one Mr. Ajayi, who was his vendor. And after the purchase of his land in 2005, he has been in possession of his own land, number 10 Pashwe, Ebowe, Lagos State, Nigeria, since 2005 till currently in late 2022 and then 2023, where he brought up dispute or claim over the land in dispute. So it is the case of the respondent that this land he is the lawful owner of this land, having been in possession for over years without any disturbance or encumbrances from any person, including the defendant and all his predecessors in title. The defendant additionally, due to the claim of the claimant that this part of his land is also an encroachment to his own, because he's claiming that this part of land is a part of his own land, there is in existence a pathway that forms a demarcation between the defendant, the claimant's land, and that of the respondent. So by his claim of the respondent land, it means he claims up to the point of the respondent land. So the respondent in this arbitration is seeking for both to be declared the lawful owner of the disputed land, and that for that footpath that demarcates the two lands to be recognized as an easement, a right of way. However, the respondent finds particularly this arbitration procedure quite strange to him, because prior to the notice of the arbitration served on him, he had not at any point given an agreement entered into any valid arbitration agreement between him and the respondent. So in addition, one of the things that the respondent is bringing forth before this tribunal is a preliminary objection for the tribunal to determine whether or not it has first, that's the power or the jurisdiction or the administrability to determine this suit. So the processes or documents that we have brought before this tribunal are our response to the notice of arbitration, our preliminary objection. Contained in the preliminary objection is the notice of preliminary objection, a supporting affidavit, and a written address. Then also we have also filed and served our statement of defense. In addition to the statement of defense is our witness statement on oath, two witness statement on oath, because we are bringing forth two witnesses, and then one exhibit and marked exhibit RI. That is, in summary, the opening statement of the respondent. The prayers we have prayed for this court are contained on the face of the motion paper, which is one, a declaration that this tribunal lacks the jurisdiction to entertain this matter. However, in the alternative, a declaration that the respondent is the lawful owner of the disputed land. And finally, a declaration that the footpath is a recognized easement. And in addition, damages to the tune of 1 million naira for the cost of instituting this suit. Thank you so much, Mr. Chairman and the honorable arbitrators.
Okay, thank you, Respondents Counsel. So, the claimants, are you ready to commence your case, to open your case?
Sorry, can I ask a question?
Yes, please.
Okay, since we have a preliminary objection on grounds of jurisdiction, court proceeding usually take pre-O before the main case is opened. I just want to be directed on that.
So we can take that at the end of the proceeding, but before then, can you state briefly what are the grounds of your objection?
All right, thank you so much. The ground of our objection is quite direct, is that our client, Mr. Dewale, had not entered an arbitration agreement with the claimant. And without an arbitration agreement, yes.
No, I didn't say you should argue it here. I just said you should mention the grounds of your
all right, thank you so much.
Okay, so what I think, right, since that preliminary objection challenges the jurisdiction of this tribunal, right, I would suggest that we take the preliminary objection, but also for the purpose of this competition, we are still going to proceed with the hearing. We'll take your preliminary objection, we'll reserve judgment, we'll proceed with the hearing as well for the purpose of this competition. Probably at the end of the entire hearing, you might know the fate of your preliminary objection, or you might not, or we might comment on the validity of the preliminary objection or not. So we'll take your preliminary objection since you appear to have valid grounds for bringing the objection. That's my suggestion. So I don't know what the chairman thinks.
Yeah, let me hear from Daniel. Hello, Daniel. Can you hear me? Okay. To save time, I agree with Chimize. So you can proceed to argue your objection, right? So essentially, identify the objection, the date it was filed, the dates of the objection, and then I make very few comments, just a few sentences. Okay, we can hear you now.
I was saying that I totally agree with Chimize in the sense that if there is a preliminary objection which affects the jurisdiction of this tribunal, then we should look at that first. So especially because the tribunal has the power to decide its own jurisdiction. Yes. So we should look at that, and then as he rightly said, defer whatever we're going to comment on it later, and then go ahead with the hearing for the purpose of this exercise.
Okay. Okay, great. So the defendants, you proceed to adopt your preliminary objection, essentially identify the document, the date it was filed, adopt it, and then speak to it in 2 minutes. I'll be timing you from here. 2 minutes to argue your objection and whatever reply that you have filed. So you are adopting both your objection and your reply in 2 minutes. The claimant will have the opportunity to also identify and adopt their response there too in 2 minutes. The time starts now.
Thank you so much. We have filed a notice of preliminary objection, which is brought pursuant to Article 4, Sub 2A of the first schedule to the Arbitration and Mediation Act, and even more particularly now, Section 19 of the Lagos Court of Appeal Law, 2018, which empowers the arbitral tribunal to entertain questions as to its jurisdiction. So we are particularly bringing it under Article 4 Sub 2A of the first schedule, and this is dated and filed the 20th day of July 2023. In support is a 9-paragraph affidavit deposed to by Mr. Adewale, the respondent. We rely on all paragraphs of this affidavit. Counsel again has filed and served a written statement on oath, wherein we have distilled the sole issue for determination to it is that whether or not this arbitral tribunal has the requisite jurisdiction to determine this suit. We wish to adopt him as our oral argument in this suit, and just as I've been given leave, I will go to the cogent areas of this particular plenary objection. Basically, the respondent's vehement contention is that there is no agreement, arbitration agreement in existence between him and the claimant. The claimant had, in their notice of plenary objection, made claims of an arbitration agreement that was entered into on the 20th.
Mr. Darlington, we can't hear you. I don't know if it's just peculiar to me, but I can't seem to hear him anymore.
I think we've lost him.
Yes, I'm still here. Sorry for that. Can you hear me now?
I can hear you now. Actually, your 2
Hello,
minutes
can
is
you
up.
hear me?
I'll give you 30 more seconds to round up.
Hello, can you hear me?
Yes, we can hear you. Can you hear me?
Okay, yes. The court held in that case that an arbitration agreement, which is a voluntary submission to arbitration, is very valid basic for an arbitration proceeding. This is even statutorily enacted in Section 1 sub 3 of the Arbitration and Mediation Act, which provides that an arbitration agreement must be in writing. We have made reference, thank you, we have made reference to paragraph 6 of the Moot Fact, which provides that wary, this is particularly contained in paragraph 6 of the Moot Fact that says, wary of approaching the court, Mr. Emiola and Mr. HJIUF have agreed to resolve this dispute by arbitration before a panel of 3 arbitrators, which means the agreement as deposed in the Moot Fact provided by this particular competition is between Mr. Emiola and Mr. HJIUF, and Mr. Adewale is not a party to same. And because he's not a party to same, the agreement between Mr. Emiola and Mr. HJIUF cannot bind our client, Mr. Adewale. And in the absence of an arbitration agreement, this arbitration tribunal is then robbed of its jurisdiction, because finally the claimants have, in response to our claim, they have said that an arbitration agreement is in existence that was entered on the 27th of July 2023. Whereas while we provided a preliminary objection, they now filed an arbitration agreement, which was dated the December 27th of the year 2005 or thereabout. So the discrepancy in the date of the letter arbitration agreement they filed on us after we filed the plenary objection shows that there was actually, in truth, no arbitration agreement, but they have tried to frame this up in their claim to say there was an arbitration agreement between them and the claimant. So our case is that there's no arbitration agreement between our client and the respondent, and the claimant, in their bid to circumvent this particular plenary objection, provided an arbitration agreement. But because in their haste to craft out things, there was a clear discrepancy in the dates, and dates are important. This shows that this is actually a crafted work. And this tribunal is well versed with the law that in the absence of an arbitration agreement, which is basic, this tribunal is robbed of jurisdiction. Therefore, it's a prayer that following the extent, you cannot put something on nothing and expect it to stand. Arbitration tribunal lies on the arbitration agreement. And in the absence of arbitration agreement, we pray this honorable court that instead of wasting public time, because in the absence of arbitration agreement, even the award given by the court cannot stand the test of appellate supervision. Hence, let this court save the time of the different parties and decline jurisdiction. May it please this honorable tribunal. Thank you, Mr. Chairman, and the arbitrators.
Okay, the claimant. 2 minutes, please, 2 minutes.
Good day, Mr. Arbitrator. I am A.O. Adeakimbami, counsel for the claimant. Mr. Arbitrator, prior to this arbitral proceeding, in a reply to the defendant's preliminary objection was filed on the 20th of July 2023. And this document or this process contains an 8-paragraph argument replying to the defendant's plenary objection raised. Alongside this also, we have an affidavit and a 7-paragraph affidavit in support of this reply to the defendant's plenary objection, dated and filed on the 20th day of July 2023, which was deposed by the claimant in the person of Mr. Eniola. In support of this affidavit and in support of the argument raised, we have the arbitration agreement as an exhibit before this arbitral panel in support of the fact that there exists a valid arbitration agreement between the 2 parties concerned in this particular dispute, which are Mr. Eniola being the claimant and Mr. Adewale being the respondent. Mr. Arbitrator, I seek leave of this arbitral panel to delve into the argument for this particular preliminary objection.
Sure, your time is going already.
Thank you, Mr. Arbitrator. Mr. Arbitrator, the issue for contention is whether or not the arbitral tribunal has requisite jurisdiction to determine the suit, to which I vehemently plead on the affirmative. Why, Mr. Arbitrator? Simply because an arbitration agreement exists between the 2 parties, being Mr. Eniola and Mr. Adewale. Mr. Arbitrator, an arbitration agreement in the case of Unisilego and Afribank was defined as an agreement between 2 or more parties where they concede to submit their dispute to the arbitration panel. And this is the bedrock for any arbitral proceeding to go on. Mr. Arbitrator, the Section 3 of the Arbitration and Mediation Act 2023 provides that once parties consent to the arbitration agreement, they are hereby bound by that result. And automatically, the arbitral panel has competent jurisdiction, Mr. Arbitrator. The arbitral panel has competent jurisdiction to sit on that particular case. It can then be said that there exists a valid arbitration agreement. Mr. Arbitrator earlier mentioned, or before we filed this reply to the respondents, we filed a notice of arbitration, and in that notice of arbitration, we made mention of the fact that an arbitral proceeding, an arbitral agreement is in existence between the two parties to this particular dispute, being Mr. Eniola and Mr. Adewale. And now, before this arbitral panel, we have also submitted, we also filed on the 20th day of July 2023, the particular arbitration agreement that exists between these two parties, being Mr. Adewale and Mr. Eniola. Mr. Arbitrator, it can further be seen that the issue of whether or not there exists a valid arbitration agreement is raised unnecessarily by the respondent, as we already provided the fact that, one, there exists a valid arbitration agreement, and now we have also established the fact that the particular arbitration agreement question is before this arbitral panel, and as earlier stated, we filed that on the 20th day of July 2023. Mr. Arbitrator, we hereby submit that the issue raised by the defendant, which is whether or not this arbitral tribunal has requisite jurisdiction to determine this suit, is definitely in the affirmative. As earlier said, there exists an arbitration agreement, and this automatically presumes the fact that this arbitral panel is of competent jurisdiction, is of jurisdiction to sit on this particular dispute between the two parties involved. Mr. Arbitrator, I hereby submit on this. Thank you, Mr. Arbitrator.
All right, thank you. So as earlier indicated, we will reserve ruling or the award on this objection to the final award itself. With this, we can proceed to hearing the case proper. Are the claimants ready?
Yes, sir.
How many witnesses do you have?
Mr. Arbitrator, the claimant has 2 witnesses.
Okay, I ready to proceed.
Thank you, Mr. Arbitrator. Mr. Arbitrator, the first witness is Tega Akimbami.
Yes, please go ahead. Or can we see her face? That would be CW1.
Yes, Mr. Arbitrator.
All right, let's see the witness before we proceed.
Okay, the witness is here. Thank you, Mr. Arbitrator. Witness, please, can you tell this arbitral panel your name?
My name is Tega Akigbami.
Thank you very much, witness. Witness, please, can you tell this arbitral panel your age and where you stay?
I'm 75 years, and I live at in Lagos State.
Okay, sorry. I'm guessing the two of you are in the same room. One of you will have to mute when the other person is speaking.
Okay,
if
Mr.
not, there will be this echoing sound.
Witness, please, can you go on? Can you state your age and where you stay?
Ugbo in Lagos State.
Thank you very much, witness. Witness, on the 19th day of July 2023, did you depose to any statement on this?
Yes, I did.
Thank you very much, witness. Witness, what do you wish to do with this statement on it?
I wish my testimony to adopt this as part of.
Thank you very much, witness. Mr. Arbitrator, the witness wishes to adopt the statement as part of the testimony for this arbitral panel. And that concludes the examination in chief for the witness.
Oh God.
All right, thank you.
So, objection. We have an objection actually. Is it right to do that?
Yes, let's hear you.
Okay, we just wish to bring to the notice of the tribunal that they said written statements on oath wanted to be tendered in evidence, or to have been said to have been tendered, sought to be tendered rather, was sworn to before an entirely different court. A mere glance at it says it was sworn at a registry of a high court in Benin City. And here is another different court that ordinarily the arbitration tribunal is empowered to take oaths by the Arbitration Act. It now looks strange and quite an abuse of court procedure, yes, for the claimant to swear an oath differently in another court and seeking to tender it in a different tribunal. This is the observation of the respondent team, and wish that the tribunal will take judicial notice of that. We'll take note of it rather.
Okay, I think it's important that we address such objections because they are material, first in learning, and then secondly, because it affects how we make progress. So Daniel and Chimeze, would like to take first bite before we proceed.
Okay, Mr. Darlington, right?
Yes, sir. Yes, sir.
Okay, so it's not compulsory that it's, in fact, it's not a practice that it will be sworn to before the tribunal. As a matter of fact, in practice, it's normally done before a notary public, and it can be done before a notary public anywhere, right? So, the Commissioner for Oaths as well has the authority to take oaths as well, right? So it doesn't matter that he did it in the High Court of Edo State. As a matter of fact, we don't have we cannot take the oaths of the witnesses before the tribunal, right? So don't get worked up over that. What appears to you to be an irregular procedure is actually fine.
Daniel, I can see you're speaking, but I can't hear you.
I can hear you.
Can you hear me now?
Yes.
Yeah. So I was saying I was smiling because that's actually the procedure. It's usually done in court or a notary public. But I can understand why you would feel that way, and I commend the observation. But just to say that in practice, as Chimeze has rightly stated, that's how it's usually done. However, I would want to make a comment on something that has passed, so that it would to shape what would going forward. So if there are issues that have been agreed to or that are established in the details of the facts of the case, I don't think it will do any good for us to go outside it or begin to question it, because if you begin to look outside the facts given, then everything becomes questionable. So this is me giving a hint as to the PO we earlier took. In my opinion, I initially allowed that PO fly for purpose of learning. But then if you see the last paragraph of facts given to you, is that both parties have now agreed, right, to settle their dispute. That shows consent by both parties to arbitrate. So this is not me deciding the PO, but me giving a hint as to any other objection or question procedure or fact as already established before this tribunal. So yes, that's my comment.
Okay, thank you. So like my colleagues have mentioned, thank you for the observation that you have raised, but arbitration is not as strict a proceeding as litigation, right? The important thing for an arbitration is that the statement on oath should be sworn to before a person who is capable of taking oaths. So essentially that can be before the notary public or before a court. For
you have made mention of the fact that the Arbitration Mediation Act mentioned that the tribunal can take oaths. Even that, if that's the case, that does not foreclose any other oath taken by any other person capable of administering oaths. I don't know if you get me. So it doesn't invalidate an oath taken, for instance, before a notary public or before the registry of a different court, right? So for that purpose, your objection is overruled, and you can proceed to cross-examine now, since the claimants have closed their examination in chief. Chisom, are you there?
Okay, so before we continue again, it's the same way we operated in the last session or with the last team. Please, can you indicate, if you write your name, indicate the team you represent or you're name for, just so we understand and we can place you somewhere.
All right, Chisom, are you there? Is it just me? I'm seeing 3 Chisoms on my screen, but none is speaking.
I see 2 Chisoms right now. Chisom Adubike. In fact, 3 now. Yes, 1, 2, 3. And none is speaking, as you earlier observed.
So it should be the same person.
In multiple
using different
gadgets. Oh, well, this is the normal occurrence with ODR, online dispute resolution. You'd have network glitches and issues in that light. So, but I assume this is not the only member of the team.
I think it's because both of them are together.
Sorry, we are lost. Sorry, but we're back here.
Okay, thank God you're found. So can you proceed with your cross-examination?
Oh, thank you so much.
Yes, and then the claimants, can we see your witness? Okay, that's fine. Please proceed.
Yes, can we see the witness?
I think he's there now.
Okay, Mr. Dewale, are you there?
It's not a witness. Is there a witness?
Eniola?
Check the witness.
Mr. Eniola? Mr. Kubami, can you hear me?
Hello, can you hear us?
Yes, I can hear you.
This man can do it.
Yes, I can hear you.
Please, can we see the witness?
Can we see the witness?
No,
It's here. It's here.
Yeah, he's
and your
visible.
time is reading.
Okay, Mr. Akim Bemi, do you know in your last land? Yes, I do. Where is the land located? It's located in Pesh, in Pella. I mean, we need the exact location. Yeah, the land is located in Pesh, Lagos State. So is the land located in the entire page?
No. Number 10 to be precise.
Okay. Okay, so what about Adewale's land, the respondent? Where is his land located at?
It's also in the same community. It's about 12 to be precise.
Okay, so I heard it clearly. You said his land is located at number 12.
For Mr. Adewale, yes.
You mean number 12, Peshwe?
Yes, in Lagos.
Okay, thank you. So the next question, a footpath divides an last land and the respondent's land. Am I correct?
Can you come again?
Did you get the question?
Please, can you come again?
The question is, so there is a footpath that divides Eniona's land and the respondent's land, right?
Yes.
Okay, thank you. So Mr. Adewale has been in possession of the disputed land for over 20 years now, right?
What do you say?
Mr.
Please, your net, I can't hear you. I can't hear you.
Sorry, can you hear us, sir?
Yes, I'm with you.
Thank you so much. We said Mr. Adewale, the respondent, he is in possession of he said he has been in possession of the disputed land. True or false?
He has been farming on the land. Like we call Vidil, he has been farming on the land.
For how long? But well, listen, the question is whether or not he has been in possession of the land, and for how long has he been in possession of that land?
I have no idea of which land are you talking about?
The land located at number 12, the disputed land.
No, the land, you asked me, the land belongs, number 12 belongs to Adewale.
Okay.
And the 10th belongs to Mr. Eniola.
Okay. Okay. Thank you so much. So, about the disputed land, for how long has Mr. Adewale been in the disputed land? For how long has he been in possession of the disputed land?
What do you say, please?
For how long has Mr. Adewale been in possession of the disputed land?
Yeah, he's not in possession of the land. He has been farming on the land.
Okay. Are you there?
Yes, I can hear you.
Okay, so for how long has he been farming on the land?
I don't know, but when a dispute arises, I did solve the issue between the parties. That Mr. Eniola is the rightful owner of the land.
Okay. Okay. So when was the first time a dispute arose in connection to the land?
Are you saying what is a please come again, please?
When was the first time a dispute arose in connection to the disputed land?
The issue between them. It was December 20 last year, 2022. The last year of December.
So does it mean that was your first encounter with the land? That is when the dispute ensued. That was your first encounter with the land.
That was when the issue between it was settled
Was that the first time you had an encounter with that land?
No.
When was the first time?
I can't remember.
You cannot remember?
Yes, we live in the community, so it has been peaceful. I can't remember.
So how long have you been living in that community?
I've been living for the past 55 years.
Okay, and you don't know when the dispute ensued, and you don't know when that was the first time you came in contact with that land?
No, that's not what I said. Last year, December, was when I came, like I interceded between the disputes of the party over the contentious land.
Okay, what is your relationship with the parties?
I'm just a community member of a community member. I am.
That's all. You're a community member. Okay. One last question. Since you have been a member of that community for over 55 years, how did the respondents come in contact with the land?
Are you saying Mr. Adewale?
Yes.
Like I said, he has been farming on the land, and I could recall when Mr. Eniola got the land from the vendor, Mr. HJIUF. Yes, yes, something like it averts to the how I put it. What I'm just saying is that Mr. Adewale has been on the land, farming on the land, but the rightful owner of the land is Mr. Eniola.
Okay. So why is Mr. Eniola the rightful owner of the land?
Why?
Why is Mr. Eniola the rightful possessor or the owner of the land?
It's because he got it from the rightful vendor from Mr. HJIUF.
We didn't get it.
You asked me why is he the rightful owner?
Yes.
And I said he's the rightful owner because like I said in my statement of Mr. HJIUF sold the land
Objection,
to
Mr.
Mr. Eniola.
Please, one last question. One last question, please. One last question.
Objection, Mr. Arbitrator.
Yes, please.
The counsel for the respondent already said that was his last question, and the witness answered the question clearly. So furthermore, there should be no questions asked to this witness.
Please, we have our time.
So because they're reading their time, I'll let them go on. Right.
Okay, please. Mr. Akimbami, which land is the disputed land? We all ask me again. Which land is the disputed land?
Mr. Arbitrator, this question has been answered before. It has been answered before.
Okay, so the way this works, right, Clements Council, is essentially because the questions are being asked to the witness. Of course, you have the responsibility to protect the witness. That is settled. But if it's a question he can answer, let him go ahead and answer. Right? The panel will take a decision on whether or not that is repetitive and whether that is disturbing or the proceeding. But I think we'll allow him go on.
As properly guided. Thank you, Mr. Arbitrator.
So, witness, which land is the disputed land?
On the number 10.
Okay. But that'll be all for now.
All right, thank you. Any re-examination by the claimants?
No re-examination.
Okay, great. Can you call the second witness, please?
Okay, Mr. Arbitrator, our second witness is the claimant himself, Mr. Eniola. Okay. Witness, can you state your name before this arbitral tribunal?
My name is Mr. Eniola.
Okay, witness, how old are you?
I am exactly 55 years old.
Witness, did you make any statement on oath prior to this day?
Yes.
Yes, I did. In Edo State.
So what would you like to do with this statement on oath?
Yes, I want this panel to accept this statement on oath as my testimony in this matter.
Mr. Arbitrator, we seek to tender the witness statement as specifically before this honorable arbitral panel. Also, Mr. Arbitrator, we also seek to tender our documentary evidence in this matter. We have filed some exhibits, which is C1, which is the deed of assignment of the disputed land. Number 2, we filed a certificate of occupancy as number 2 exhibits, and we also filed the survey plan of the disputed land. Mr. Arbitrator, the deed of assignment is marked C1, or we would like to mark it C1, and the certificate of occupancy, Mr. Arbitrator, is marked, we would like to mark it C2, and the survey plan, lastly, we would like to mark it as C3. Thank you, Mr. Arbitrator.
Chairman of the Arbitral Tribunal,
Did you file any list of documents?
Mr. Arbitrator, we did not, we filed a list of documents to the defendants. In the mail we sent them, we filed a list of the exhibits to the defendants. We filed, like I said, the deed of assignment, certificate of occupancy, and the survey plan. However, we filed them individually. We did not compile them in a single document, but it was in the Google Drive. We served the defendants and the foundation, Mr. Arbitrator.
Because from the documents we have, I can't see any list of documents, but I can see your deed of assignment. I can also see your certificate of occupancy and then the survey plan. But there's no list of documents that accompanies this document. And then again, confirm, you're just marking them now. They were not marked initially as exhibits to identify which of them is which.
Mr. Arbitrator, that was an oversight on our part with the claimant. We filed them individually, assuming we filed them in a single document. I'm sure we would have put a list of exhibits. However, we are very much sorry, Mr. Arbitrator.
No, there's no problem. We just needed to note that point. So that's fine. Your deed of assignment is C1. The certificate of occupancy dated 25th day of May 2005 is C2. And then the survey plan drawn by Mr. Eniola is C3, right? Those are the 3 documents that you've just tendered.
Mr. Arbitrator, this is the counsel.
Yes.
For the claimant. I'm sorry, there was a glitch in the network, and we are working.
So I just want to confirm, you've just tendered 3 documents: the deed of assignment. Deed of assignment was entered on the 5th day of May 2005. That's Exhibit C1. And then you equally tendered the certificate of occupancy dated 25th day of May 2005. That's Exhibit C2. And then the survey plan drawn by Mr. Eniola as Exhibit C3.
Yes, Mr. Arbitrator.
Yes, so please proceed.
Thank you, Mr. Arbitrator. We are done with examination in chief. So the defendant counsel can proceed for cross-examination.
All right. Thank you. Thank you, Chimeze. Cross-examination, please, the defendant.
Mr. Arbitrator, please, we plead for 2 minutes, for our network to be restored. We plead for 2 minutes.
Okay, please go ahead so that I can make progress.
Thank you very much, Mr. Arbitrator. Mr. Arbitrator.
Yes, are you back?
This is the counsel for the claimant.
Yes.
The defendant can proceed with their cross-examination.
All right, thank you. Defendant, please proceed. Your time starts now.
All right, thank you so much. Just to be kindly directed again, during the preliminary trial or something where we had the guidance, we were told that we will have opportunity to object to documents. So when do we do that exactly? Because they have tendered 3 documents, and while we consider those documents, there are cogent things we could object to those documents. So how are we guided on that?
Okay, please state. Okay, so we'll hold on with the cross-examination. State your objection. Again, we'll deliver the ruling towards the end of the procedure. So, Team Pearl, listen to the objection so that you make a 1-minute response. Your objection is in 1 minute. You respond in 1 minute, and then we'll defer a word on that, a ruling on that to, the conclusion.
All right, thank you. I'll take them. So they tendered documents, so that first the deed of assignment, wish to how do I get to that? we wish to let the panel or the arbitral tribunal acknowledge that in the written statement on oath of the witness, he said he is the registered owner of number 12 Pashway. But in paragraph 1 of the deed of assignment, it says the assignor is a registered owner of a parcel of land located at number 12. A deed of assignment, Pashway. So a deed of assignment they have tendered before this court is a deed of assignment of a different land from the land they have said in dispute. Deed of assignment for number 12, whereas they have contended for number 10. That again means that this deed of assignment does not have nexus to the land in dispute, according to their claim. Secondly, they have served on us a purported certificate of occupancy, to which they said is a certificate of occupancy for that particular land. But a mere glance at the certificate of occupancy says certificate of occupancy under the Land Use Act, number 6 of this, and this is certified that the Lagos State certificate of occupancy number 12 again. And to whom was the certificate of occupancy issued? It is settled law that you must establish one condition, legal custody, that you are the owner of a document to which you want to tender before any court or a tribunal. For them to tender a certificate of occupancy that it was not issued to anybody, no name on it, how do I know that that actually is issued to them or is issued to another person? Again, this shows that this document actually does not belong to the claimant, which he had tendered before this tribunal. And lastly, they tendered a survey plan. A survey plan that we contend is hugely defective. A mere glance at that survey plan sees that it offends Part 3, Section 28 of the survey law of Lagos State, which provides that a survey plan must carry a plan number. The survey plan they gave us does not have a plan number. All right, the survey plan again they gave us conclusively, it does not have a stamp of the surveyor, and it does not have the stamp of the surveyor, and there's no indication that it has been registered with the surveyor general. All these things shows that it affects admissibility of those documents. Thank you.
Okay. Thank you so much, Isom. Any response quickly from Team Pell? I think this is something we can even address before we go so far.
Yes, Mr. Abjudo, there's a response.
Yes,
Mr.
1 minute, please. 1 minute.
Thank you very much. On the issue of the survey plan the survey plan was signed by the surveyor, being Mr. Eniola, who is also the claimant, as is a professional surveyor, as stated in his statement or note, which is brought before the notice of this arbitral panel. If only I could show this arbitral panel how the name of the surveyor is written just right under the survey plan, rather, which was tendered before this honorable court.
You can see it, so maybe you can move to the next one if that's the.
Also, Mr. Arbitrator, on the issue of the certificate of occupancy, the respondent is saying that this certificate of occupancy has no name. However, the certificate of occupancy is a certified true copy, and it is not within our control that this particular certificate of occupancy has no name attached to. However, it is certified, and this shows that this particular copy came straight, Mr. Arbitrator, from the Lagos State authorities who issued this particular certificate of occupancy, as we are not deficient in any certification or whatsoever. So the issue of name is rather technical, and it should not be looked at on the side of the respondent. Thank you very much, Mr. Arbitrator.
Okay. All right, thank you. So I think we can deal.
Let me just put two questions to you. Ms. Egberiemu, right? Oganetega, is that correct?
Yes, Mr. Arbitrator.
Okay. You said that the certificate of occupancy is certified, duly certified. Can you please look at that document again and be sure of what you are telling us?
Yes, Mr.
Where was it certified on the document?
Like the government. Thank you, Mr. Arbitrator. Mr. Arbitrator, this particular certificate of occupancy was signed by the governor of Lagos State on the 25th of May 2005, rather. And it also
No,
shows
I think what the question here is this certified?
Yes.
And where is the certification? I know you're looking at the word that says this is certified. Is that what certification means? When you're looking at it from the context of an objection. We're not upholding their objection here. We're just asking you because you made mention of the fact that it's certified.
Again, look at your survey plan.
Yes, Mr. Arbitrator.
Look at your
Yes,
survey
just for
plan.
clarification. Yes, Mr. Arbitrator. The survey plan, with respect to the survey plan, the respondent argued that the survey plan carries no name of the surveyor, to which I replied on the fact that if you look at the left hand side of this particular survey plan, the name of the surveyor is stated explicitly there, being Mr. Eniola, who is a professional surveyor. Then secondly, Mr. Arbitrator, on the issue of the certification, I said that the governor's signature is apprehended on this particular certificate, and it also carries a certification just on, it also carries a stamp rather, just on the right-hand side of that particular certificate. Thank you, Mr. Arbitrator.
That's fine. Chimes, any further comments before you rule on this?
Okay. So on the point, on the discrepancies as to the actual land, the Mr. Darlington, right? Is that Mr. Darlington or Mr. Harris in Chisholm?
Yes, yes.
Okay.
Yes.
They made a point that I thought it's important we point out again. In your statement on oath, you said that the claimant is the registered owner of parcel of land located at number 10 Perchway, right? And then in the deed of assignment, it shows that what was assigned to the claimant was number 12 Perchway. And then again, even in the statement on oath, the defendant, you said that the defendant owns number 12 Perchway. Right, so could you please quickly reconcile these discrepancies and let's know where the problem is coming from?
Wait.
Did you get me?
Mr. Arbitrator, yes, we get you correct, Mr. Arbitrator. Okay, firstly, what I would say is that was a mistake on our part, and the disputed land in this matter is actually the one owned by Mr. Eniola. And yes, so the certificate, although it was a mistake, we plead that this arbitral panel overlooked that error, which was dangerous, and seek to tender that document as.
Okay, so, well, in any case, I think this is something that you should address at the address stage. I mean, even the objection of the claimant should not affect the admissibility of the documents. We'll look at the weights to be attached to the documents. Maybe at the address stage, put your arguments together to address us on whether there was a mistake somewhere or whether, you know, the mistake goes to the root of the matter.
Yes, so like Chimezi rightly said, so generally, and this is to Chisholm now, there are some objections really that affects admissibility, and there are some that are matters that affect the weight to be attached to the document. So issues of discrepancies are issues to say, oh, you have not established this case because, you know, there are discrepancies. So these are issues that you should address in your closing address, and issues that will be that will weigh on the mind of the tribunal in deciding one way or the other at the end of the proceeding. But it does not affect the admissibility of documents, so they remain admitted and marked as they have been so marked. Can you proceed with your presentation now?
Yes, thank you so much, Mr. Chairman.
Right.
Thank you so much. All right, so Mr. Ajayi, are you there? Right? No. It's not Ajayi.
Yes, I am.
Sorry, Mr. What's your name again? Remind the court.
My name is Mr. Eniola and not Mr. Ajayi.
All right, sorry for that mistake. All right, so Mr. Ajayi, sorry, Mr. Eniola, sorry, pardon me for that. Mr. Eniola, you own the disputed, you claim that you own the disputed land.
Yes.
How did
I don't claim that I own the disputed land on number 10 Peshway, Pella Ogbowo, Lagos.
How did you come into ownership of this land? Yes, like that.
It was purchased from the previous owner, and I obtained a registered deed of assignment in 2005.
So who is the previous owner?
Mr. Ajayi, who you have been mistaking my name with from the beginning of your question.
All right, thank you so much. Right, so I would be right to say that any right or interest you have in the said land was passed on to you from Mr. Ajayi, right?
Yes, passed duly and in full.
Okay. When did you bought this land in 2005? And am I correct to say in your statement on oath, you made averment that you gave permission to the respondent to farm on this land? Is that correct?
Yes, that is exactly on the 8th paragraph. I did give permission for Mr. Adewale to occupy and cultivate, especially the word cultivate, my land.
Okay, all right. Okay, when did you give him the permission to start farming on the land?
I cannot quite pick the particular year because it was a gentleman agreement. A man who wanted help, whose land was just beside mine. I just wanted to assist, and I cannot remember the exact year, but I know I gave him that space to cultivate my land because it was just adjacent, it was just beside, it was just opposite.
All right, all right. Next, so but he owns a land beside yours, number 12, right?
That is very true.
And this is okay. This is land. Is he farmed on it? Does he farm on this his land?
The land he owns. Yes, he farms on it, and he also farms on mine. He needed a bit of an extension, and I allowed him.
Okay, I want to refer you to paragraph 8 of your statement of claim. In that place, it says it's deposed by your lawyers that the claimant denies that he gave permission to the respondent to occupy and cultivate the land openly, peacefully, and without any interference. And in your statement of claim, which you have even admitted in this court.
Mr. Lawyer, please, I would like to, yes, go ahead.
All right, I said, I'm reading your statement of claim. If you have it, look at paragraph 8.
Yes,
it says,
I am there.
okay, you have seen that the claimant denies that he gave permission to the respondent to occupy and cultivate the land. And in your claim, you said you gave him permission to. Why the contradiction?
There is no contradiction as to what I said in paragraph 8. My witness statement on note has already been tendered. I said I agree to the notion that has been raised that I gave permission. Yes, I gave permission to him to occupy and cultivate my land without interference. Okay. I did not give him the land in exclusive possession. You can also find that if you check well in the witness statement on oath, which I believe you must have access to.
All right. Next question. Since Mr. Ajayi is your predecessor in title, and he's the one to whom you gained all the interest in this land, when these disputes arose as to the ownership of the disputed land, and he's the one you got this land from, did you at any time make reference to him towards the disputed land?
Could you break down what you mean by the word reference?
Did you speak to him at any time? Did you interpret? Did you get back to him that a land he had sold to you was disputed?
Mr. Lawyer, I had all legal documents necessary. I was under law possessing a land that was rightfully mine. There was no need discussing with a man who had already bought a land. We don't have personal relationships. I paid my money, got my necessary documents, and someone living close to me, we thought we were just neighbors who could be friends, who could farm on my land. Why would I make a big deal out of a little issue? This matter has been raised by a man who wants to take possession of a land which is not his by right, and should not be an issue. I never saw it as an issue until it was brought up as a massive issue.
Okay.
Like,
all right,
the other person who was brought here testified. He discussed between two of us and settled it amicably. It was an amicable settlement. He was a member of the community, a farmer who.
All right, I've gotten your answer to save time. So to save time, I want to ask for confirmation. Can you state which land was sold to you?
The land sold to me is
Yes.
the land on number 10.
All right, thank you.
Footpath in between, separating it from number 12.
Okay, okay, okay. All right, okay. So this footpath separating it from number 12 has been in existence for how long?
It has been in existence for as long as those lands have been there, because that's the road the village people used to access deep farmland and also access the main road.
Okay. Do you have any form of proof of agreement of that permission between you and the respondent? Because the client you called, the witness you called said it wasn't. So do you have any proof of that agreement that existed, either documentary, any of such, where you gave permission?
Yes, I said, and I will re-emphasize, that was the gentleman agreement between two neighbors. Farm on my land because you wanted extension. I was not using that space at the time. I needed not to overgrow. A gentleman agreement. I had my necessary things. Why would I anticipate the possibility of a contesting of my land when I had all the necessary documents?
All right.
We should discuss
all
that
right.
not knowing that this will come up.
Okay, okay. In the absence, so when you I think that's all. That's right. Okay. Mr. Eniola, thank you so much for your time. That will be all for the cross-examination. Thank you.
Thank you, Mr. Lawyer.
All right, thank you.
So
Is there any re-examination by the claimants?
Yes, Mr. Arbitrator, there is re-examination. So, okay, witness, did you or did you not give permission to the defendant, Mr. Adewale, to farm on the land?
I did give permission for him to farm on my land. I didn't give him absolute possession of my land, only permission to cultivate.
All right, that'll be all.
All right, thank you. I suppose at the close of, you have mentioned you have two witnesses. I suppose that's the end of the claimant's case, right?
Yes, Mr. Arbitrator, that's the end of claimant's case.
Okay. The defendants, are you ready to open your case?
Yes, Tribunal, yes.
Okay, can you please proceed? How many witnesses do you have?
Just two witnesses.
Can you call your first witness?
Okay, my first witness is Mr. Adewale. Mr. Adewale, are you there? Mr. Adewale. Okay, we'll just go ahead to call the second witness.
Okay. Mr. Jayi?
Yes, I am.
Mr. Jayi. All right, thank you. Please, can you tell this tribunal your name?
Yes, I am Mr. Jai Emmanuel.
right? How old are you?
I'm 70 years of age.
Did you make any statement in this before this particular tribunal?
Yes, I did.
All right. What will you want to do with that particular statement?
Yes, I would love to amend some paragraphs of the affidavit before adopting same as my evidence in this suit.
Okay, you want?
Sorry. So these are an oath, right? We cannot amend an oath that you've already deposed to. Ordinarily, what will happen is that before the proceeding, you will have deposed to a fresh one.
Okay.
Do you understand? Yes. So that is not permissible in a regular proceeding and also in arbitration because it's an oath. You've already deposed to it. You can't change that now. Of course, in the course of your examination, if you come across, you can do something about it. But for now, you can't change what you have already deposed to for those. Right?
All right, sir. All right, sir. Thank you.
All right. So, Mr. Will you want to? So, what will you want to do with the statement then?
Yeah, I wish for the arbitration panel to adopt same as my evidence in this suit.
All right, that is okay. Mr. Chairman and the honorable arbitrators, we wish to tender the witness statement of the RW1, that is Mr. Jai, to as the witness statement as his evidence in this particular suit.
Noted, please proceed.
Thank you so much. In addition, Mr. Ajayi, you made reference to a particular survey plan in paragraph. Let me get the exact paragraph. Our time is in paragraph 9 of your statement. You made reference to a particular survey plan.
Yes, I did.
That survey plan, what would you want? All right. Who is the survey plan with?
The survey plan is with the claimant.
And you have a copy of it?
Yes, I do.
Okay, that survey plan, would you want to, what would you want to do to the survey plan?
Yeah, I would want the court to adopt. I want to tender same. I want to tender it and the court to adopt as an evidence in this suit.
All right. The honorable tribunal wish that a survey plan annexed to the processes of the claim of the respondent be admitted and marked.
Any objection from the claimants?
Mr. Arbitrator, yes, we have an objection before we proceed to cross-examination. Yeah, our objection is based on the witness statement on oath. Mr. Arbitrator, the witness statement on oath was sworn before an incompetent person. Their statement on oath was sworn before the secretary of the arbitral tribunal. Mr. Arbitrator, the secretary of the arbitral tribunal lacks the competence to administer statement on oath. The person who has, according to the law, the person who has the competence to swear and to issue a statement on an oath is the commissioner administer statement on oath. She cannot issue statement on oath, and therefore we seek that this arbitral tribunal throw away the statement on oath because it is incompetent, it lacks merit. And the witness should not testify. Also, Mr. Arbitrator, we are on our second issue of the objection. And in every statement on oath, according to the law, Mr. Arbitrator, the right phrase for a statement on oath was not used. Mr. Arbitrator, for a statement on oath to be very effective, there's a clause there that should be added at the end, which is, I do solemnly swear that I depose this in good faith. But Mr. Arbitrator, their statement on oath lacks this clause, and such is just a mere piece of paper, Mr. Arbitrator, and it should not be relied on. the witness should not be allowed to testify because he lacks, or rather, his statement on oath should not be admitted before this honorable tribunal because it is incompetent and it lacks merit. Thank you, Mr. Arbitrator. That is all for our objection.
Okay, so if I get you correctly, this is an objection to the adoption of the witness statement on oath and not the evidence that have been tendered.
Yes, Mr. Arbitrator, it is an objection to the statement on oath.
Okay, so we will comment on it subsequently, but just to mention that next time, right, be very proactive so that when the tribunal has taken, you don't bring the tribunal back or even the court, right? When something is about to be tendered and you have an objection, you raise it timelessly because we have proceeded from the point of adopting and then we are at the point of tendering evidence. Do you understand? So be more timeless. Yes. So I think it's proper we comment on this at the end. Or Chimeze, do you have any comment? I can see you're not muted.
So let us leave it to the end of the proceedings. We'll comment on everything, right? So we'll just proceed now, and then at the end we'll note your point and then comment on it. So that we don't waste time.
Hello,
okay, do you want to respond? Yeah, yes, the defendant is supposed to respond. So respond,
yes.
please. 1 minute.
Yes.
Yes. Thank you so much. Our response to that is that, particularly a clear glance at section 338 sub 2D of the Lagos State Arbitration Law 2009. It empowers, that particular section clearly empowers. As you know, I have time, I will read exactly the provision of that section. But that section, while making provision for the powers of an arbitral tribunal, empowers the arbitral tribunal to take oaths. This is as opposed to the provision of the Oath Act that makes provisions of people that take the oath, which are commissioner for oath, the notary public, and the rest of them. And conventional practice may have it that the notary publics, the commissioner of oath, do that. But a clear glance at article of that particular section 38 sub 2D of the Lagos State Arbitration Tribunal of the Arbitration Law 2009, it empowers an arbitral tribunal to administer or to take oath or affirmation. And if there is a law enabling this act to be done, then it means that the objection of the claimant do not hold sway. And the executive secretary, again, by the provision of Article 3 and 4 of the arbitration rule of the Lagos Court of Arbitration 2018, it provides that the executive secretary of the arbitration tribunal is the one that receives the document and processes and statement of the witnesses. So at the point of receiving it, the executive secretary enforces or puts in force that powers given to the arbitral tribunal in section 38 sub 2D of the Lagos State Arbitration Act. And if this act provides so, we find the objection of the claimant unfounded. May it please this honorable tribunal.
Okay, Mr. Darlington, right? Please, can you read verbatim the provisions of that law?
Yes, yes, I
tribunal. Yes, please.
Yeah. Okay. Hey, sorry, a minute so I get it. I had it in my just very few minutes. Okay. It says that 38 says powers of the arbitral tribunal. It says that the parties are free to agree on the powers exercisable by the arbitral tribunals regards remedies. 2, unless otherwise agreed by the parties, the arbitral tribunal has the following powers. A, the arbitral tribunal may make a declaration as to a matter to be determined in the proceeding. B, for the particular one I relied on is D. So let me go to D. D says the arbitral tribunal shall, unless otherwise agreed by the parties, have the power to administer oaths or take the affirmation of parties and witnesses appearing before the arbitral tribunal.
Okay, I now have 2 questions for you. One, this present proceedings, is it being conducted pursuant to the Lagos State Arbitration Act or law that you've just read out for us now, or the Arbitration and Mediation Act 2023?
The Moot fact sent to us indicated that the
I can see that,
all of that
Daniel
were
is speaking.
located in Lagos,
I believe
and
he's
all the
muted.
defendants were
Hold
located.
I said that was exactly going to be my question before he started reading out the Lagos state law.
Sorry, I didn't hear you.
Can you hear me?
No.
Can you hear me?
I can hear you now. Yes, I can hear you now. Yes, I can hear you now.
I said that was exactly going to be my question, to ask if that is the law that governs this arbitration, whether it is the Lagos state law or whether it's the Arbitration and Mediation Act of 2023, and why you are quoting the Lagos state law. A party settled as to whether it is the Lagos state law that governs the arbitration, because I know someone else had brought this up about oaths earlier, and then it was under the Arbitration Act, and this time you're bringing it up and it is under the Lagos State's arbitration law. So it would just be proper for you to answer that question before we proceed.
Because you see from your own process, there's the respondent point of defense brought pursuant to Article 21 of the first schedule of the Arbitration and Mediation Act. Even from your own process, you've alluded to the fact that. So why are you quoting Lagos State arbitration?
That is why it is important that he answers it. So what law exactly? Or you're looking for which works for you.
Sorry. Can I answer, sir?
Yes, please, no. Answer.
Okay. I think that while I read the Moot fact, I don't know, but this is what I think. When I read the Moot fact alluded to fact that the land, the parties are all located in Lagos State, and that's the disputed land. And assuming we at no point did we kind of exclude the application of any of those laws or state particularly, that's between the claimant and the respondent, which particular law is to be cited, or excluding or including anyone. So we had made reference, in fact, even the claimant had also made reference to the same law that I actually cited. They have made references to them in their processes. So we didn't at any point state that this is excluded or this is not excluded. So that's why I didn't really know. Sorry, I did that. So sorry.
No, if you've chosen a law that should apply, you by yourself, in your
sorry,
claims,
did you hear me?
Of course, we've heard you. We've heard you. Can you hear me?
So my second question. So my second question, right? The provision that you read out, right? Does it apply to taking oaths of witnesses, written statements? Does it give the arbitral tribunal the powers to administer oaths of witnesses? Or does it give the arbitral tribunal the power to take affirmations of the witnesses before the tribunal, right? So those are two different things. The oaths, the written statement of the tribunal of the witness would have been taken before someone who has the power to administer oaths. And then the affirmation of the witness before the tribunal is an entirely different thing, right? So with respect to the latter, of course, there's no doubt that just like the way you do in court, the witness comes and then he says that what I'm going to say here will be the truth, the whole truth and nothing but the truth. That's an affirmation or swearing of the witness. The witness is sworn on oath. So now advise us based on what you've read. Does it extend to documents that the witness would submit before the tribunal having the power to administer oaths, so to speak? I'm saying now, let's assume that you are even, I mean, the provision of the law that you've cited is, let's assume that it's in order.
Okay, I think I don't know, probably I misinterpreted that section while I did get my witness statement on oath. No, I felt that their act that says administer or take affirmation, and had acted in that regard because most of tribunals, the registrar of those tribunals is usually the secretaries of the tribunals, and that was why we acted the way we did.
Okay, no problem. Daniel, you have anything to say?
Okay, go ahead. Hello, sir.
Yeah, Daniel. Hello, Daniel.
So I thought I couldn't hear Chimeze when he was speaking.
Yeah. Oh, okay. I think you're frozen. Daniel, I'm ready. We can't hear you. I think you're frozen or something.
Can you hear me now?
Can hear you now.
Good. So I couldn't hear Chimeze while he was speaking, but I could see him smiling. I wanted to also say something, but you know, I think we are dwelling a lot on this issue, but that's partly learning as well. So you said Secretary of Tribunals. The Secretary of Tribunals, their function is mostly just to assist. So that even that explanation does not would not avail you. So I would just say, you know, is to have better understanding of that, and then we'll move on. The Secretary of the Tribunal is just to assist, basically. He doesn't play any serious role, communicates from the tribunal to the parties to tribunal, and that is as the middleman, really. So I don't even think, even in affirmation, Secretary of Tribunal would even do anything there. From my experience, I've not seen Secretary of Tribunal coming to while hearing is going on, like we are here now. There's a Secretary to the Tribunal, right? There'll be no question put to the Secretary of the Tribunal. There'll be the Secretary of the Tribunal will not be answering any question. Neither will the Secretary of the Tribunal be asking the witness to do anything. So I just wanted to just help clarify that, subject to what they was saying. I didn't hear him.
Okay, I mean, both of you have said, I've made the same points.
It's the same point. Oh, I didn't hear.
Yes, essentially. So the defendants, I hope you've heard. I know you, if you're going to rule on this, you know the direction we're going to.
Yes, we do.
But
Right.
even then again,
yeah.
Even then again, I actually have an opinion as to the main objection itself, right?
Yes.
I don't know. Maybe I should just say, as to the main objection, they have raised the objection that it was not sworn before someone who has the power to take oaths. That it was before the tribunal. I would just say, yes, the objection is well-founded. But then again, what you should know again is this is arbitration. So arbitral tribunals do not like to apply the strict rules that applies to litigations and all that. And then again, even if we should go by your own objection and even try to apply the strict rules of litigation, it still will not be sustained. One, because yes, that oath is defective, but we are assuming that whatever the witnesses that come before us here, we affirm them again before they proceed to take oath. So that subsequent affirmation actually cures the defect in the first oath taken by that is defect that you've claimed to be defective now, right? So, I mean, we're all learning. So these are things that you should actually note. I don't know what other my co-arbitrators think about it.
I agree with you. And please note that the Evidence Act doesn't really apply to arbitration proceedings.
Yes.
It doesn't apply.
Yeah.
So just keep that in mind while you have to go on.
Okay.
Mr. Chairman, sir. Mr. Chairman.
So are we supposed to? We're supposed to proceed with. Is it cross-examination now?
Yes,
Sorry.
Mr. Arbitrator.
Yes. Yes.
Okay.
Just keep your phone there.
Okay. So let's proceed then.
Thank you, Mr. Arbitrator.
Again, sorry. You tendered a document, right, Mr. Darlington? Mr. Darlington and Chisom. Can anyone hear me?
Yes, I can.
We can hear you, sir.
Okay, so I asked, you tendered a document, Mr. Darlington and Mr. Chisom, you tendered a document through your witness, Mr. Ajayi, you tendered a survey plan. Am I correct?
Yeah. So sorry, we didn't hear that.
Did you tender any document through your witness?
We didn't hear you. The network is breaching.
Oh, sorry. Can you hear me now?
Yeah, clearly.
Okay, so you tendered a document, a survey plan through your witness, Mr. Ajayi?
Yes, we did.
Is the survey plan different from the one tendered by the claimant?
There's actually a difference between the two, yes.
There are two different survey plans. I don't know, I think I have one with me here, the one tendered by the claimant. I don't know if my co-arbitrators have a copy of the survey plan that you tendered. Kigai and Daniel, do you have a copy of that document? Hello?
Am I to respond?
No, I'm asking, so you forwarded a document to us, right?
Yes, I did, which we just tendered the survey plan.
Well, I have just one of the survey plans, and that's the one tendered by the claimant. I can't seem to find yours in my file. But if you say you sent this document, I believe we should have a copy of it.
Their own survey was attached to their respondent process. It just in that their respondent processes.
Okay, no problem. So that's fine. So let's proceed with cross-examination. Ms. Ogenetega Igberiemu, am I correct? Is it Ms. Ogenetega?
Anu, sir. Anu, Mr. Arbitrator.
Sorry?
A.O. Ade Akimbami. Yes.
Ade Akimbami. You are Ade Akimbami, right?
Yes, Mr. Arbitrator.
And your colleague is Ogenetega?
Yes.
Okay, so I've been mixing the names up. No problems. Okay, so proceed.
Thank you, Mr. Arbitrator. Okay. Witness. Thank you very much. Witness, please, can you state your name for verification purposes?
Yes, I said my name is Mr. Ajayi Emmanuel.
Okay, thank you very much, Mr. Ajayi Emmanuel. So, witness, do you assent to the fact that everything within your statement note is true and nothing but the truth?
There are discrepancies in my statement. That was why I wanted to amend my statement.
There are discrepancies in your.
Yes,
so
that was why I wanted to amend it.
You are attesting to the fact that your statement on oath is not the truth. Is that what you are trying to say? Yes or no?
That is not what I'm saying.
Furthermore, moving forward, witness. Witness, do you have a good memory?
Yes, I do.
Thank you very much, witness. Witness, who are the concerned parties to this particular dispute?
To this particular dispute, that's the claimant, Mr. Eniola, and the respondent, Mr. Adewale.
Thank you very much, witness. Witness, can I avert your mind to paragraph 4 of your statement on oath? And I would like to read it to the hearing of this arbitral panel, where you stated that I assigned the aforementioned land to the claimant, who is Mr. Eniola, through a registered deed of assignment on the 5th of May, 2005. Am I correct? Is that what is written? Is that what you wrote in your statement on it? Yes or no?
Yes, that's what I wrote.
Thank you very much, witness. Meaning that Mr. Eniola is the owner of this land, yes or no?
Yes, he's the owner of number 10. Yes, he is.
Thank you very much, witness. Now, witness, moving forward to paragraph 10 of your statement or note, you made mention of the fact that Mr. Ajayi is well informed of the boundaries and extent of his land. Mr. Witness, please, can you tell this arbitral panel, who are you claiming to encroach on Mr. Adewale's land?
Please come again with your question.
Okay, witness, I said in your statement on oath, you said that a particular party is laying a claim to Mr. Adewale's land. Yes or no?
True.
Am I correct?
Yes. Yes.
Okay, thank you very much. Now, witness, as highlighted in your statement on oath, particularly paragraph 11, you said that Mr. Ajayi is this particular party that has laid a claim to this particular disputed land. Am I correct? Yes or no?
The correct name should be Mr. Eniola. The correct name is Mr. Eniola.
Witness, but in your statement on note, you stated that Mr. Ajayi is the person that laid claim to this particular land owned by Mr. Adewale. Am I correct? That is what you stated in your statement on note. And you have sworn an oath before this arbitral panel that everything in your statement on note is true. So therefore, the party that laid claim to this particular land is Mr. Ajayi. Am I correct? Yes or no?
I believe I have been...
Objection, objection, my lord. Objection.
Let's hear you.
We have an objection. We have an objection to the question, to the line of questioning.
What's the objection?
Our objection is that the claimant counsel seemed to impose an answer on the witness, even after he has vehemently taken his position. And we find that against the person of the witness.
No, I'm not sure that's correct, right? So what the layman's counsel has asked the witness is to confirm what he has stated in his witness statement on oath. So it's either a yes or no answer. I'm not sure she has tried to impose any answer, or direct him to give a particular response.
Counsel, except you are saying that he should not rely on his witness statement, or you want to withdraw it. That is simply what they are trying to confirm.
Thank you very much, Mr. Arbitrator. Thank you very much. Furthermore, witness, in paragraph 12 of your statement on us, you also stated that you have on several occasions advised this particular Mr. Ajayi on desisting from laying claims to Mr. Adewale's land. Am I correct?
Yes.
Thank you very much, witness. Mr. Arbitrator, no further questions for this particular witness. As this particular witness has introduced, thank you very much, Mr. Arbitrator. No further questions for this witness.
Thank you. Any re-examination?
Yes, there is.
Okay, proceed.
In your, all right, thank you. In your statement, in your cross-examination, you said that there are discrepancy in your statement. The word discrepancy is ambiguous. Can you tell this tribunal what exactly were those discrepancy and what you said are your statements.
Yes, there were typographical errors in my
Yes,
written
witness, you can go on.
position. Yes, there were typographical errors in my written position. The names where they were referred to as Ajayi are supposed to be Eniola, because my name is Mr. Ajayi Emmanuel and I am not a party to this suit. So the obvious party to this suit are Mr. Eniola and Mr. Adewale. So the correct party there should be Mr. Eniola, not myself.
All right, okay. That will be all then. We are done. We are done with him. That's the end of our cross-examination. Re-examination rather.
All right. So in the same order, will the claimant please proceed with final address?
Oh, sorry, we still have one more witness.
Oh, you have a witness?
We just got the first witness and we are just finished his own and then we want to call
Okay, so you have Mr. Adewale, the second witness.
Yes, Mr. Chairman.
Okay, please call your second witness. Apologies.
Okay, Mr. Adewale, are you there?
Yes, I'm here. Can you hear me?
Yes, thank you. Please remind this honorable tribunal of your name again.
Okay, my name is Mr. Adewale Johnson.
Okay, thank you very much. Did you make any written disposition on oath?
Yes, I did make a written disposition on oath.
Okay, please tell this tribunal, what do you intend to do with this disposition on oath?
Okay, I intend.
Why can't we see the witness?
Witness, please, can we see you?
Yes, I am working on that.
Oh, yeah, that's good. Mr. Shaman, please, can we give the witness a couple of minutes? Okay, thank you.
Yes.
Thank you.
You should come and look at the children and look at you.
Okay, witness, are you set? Mr. Chairman, I'm sorry for that breakup in connection. We had some technical issues.
Can you hear me now?
Witness, are you with us?
Yes, I'm with you.
Okay, thank you. Yeah. So the last question was, did you make any written disposition on oaths?
Yes, I did make a written disposition on oath.
Okay, Mr. Adewale, what do you wish to do with this disposition on oath?
Okay, I wish that this disposition on oath would be adopted and tendered as my witness and evidence in this tribunal.
Okay, thank you. Mr. Chairman, the respondent witness to Mr. Adewale wishes to tender this witness statement on oath as evidence in this trial.
Yes, please go ahead. It's noted.
That will be all for cross-examination for examination in chief.
Okay, you're not tendering any document through him, right?
No, Mr. Chairman.
All right, that's fine. So cross-examination, please.
Okay, witness. What's your occupation?
Okay, I am a farmer. A farmer.
Yes, for how long have you been farming?
Okay. Well, throughout the time I know that I've known things in life. That's when I started farming. It's been like I've been a farmer to close to 69 years. Let's just say 40 years or 50 years of my life I've been farming.
40 years of your life. All right, witness, on your statement on oath, you, paragraph 2 precisely, you said that Mr. Eniola acquired title to the land situated at number 10 Pesla Way, Pela Ibowo. Is that correct?
Sorry, I didn't hear you. What did you say?
I said on your statement on paragraph 2, you made mention of the fact that Mr. Eniola acquired title to the land on number 10 Pesla Way. Is that correct?
Yes,
Witness,
it's correct.
Witness,
yes.
You also, okay, witness, you also made mention of the fact that on paragraph 7, you made mention of the fact that that the footpath is an easement. Is that correct?
Yes, it is correct.
Witness, do you own this footpath?
Okay. Well, the thing is that when two persons
yes or no, witness, witness, do you own this witness?
No one in particular.
Do you own this footpath? Yes or no?
No one owns the footpath.
No one owns the footpath. Thank you very much, witness.
Yes.
Next question, witness. Witness, on paragraph 5 of your statement on oath, you said that upon the claim of Mr. Eniola over the disputed land, you approached Mr. Ajayi, the vendor. So for how long have you known Mr. Ajayi?
Okay. The thing is that when I started cultivating in that land in around the year, that should be 1998. So when I got there, it was a vacant land and no one occupied the land. And I've been in possession of that land even at the time when Eniola bought the land. So when I got there, both Mr. Ajayi and all surrounding people in the community, no one laid claim to the land or disturbed my possession or use of the land. So
thank you very much.
I've known him since I started cultivating on that land.
Witness, thank you very much. Now, on your statement on those paragraph 3, you said that you have continuously occupied the disputed land. Is that correct?
Yes, it's correct.
And by occupying, you mean that you have cultivated the land openly. Is that correct?
It is correct.
You live on the disputed land.
I use it for my farming purposes.
Do you live on the disputed land, witness?
I use it for my farming purposes.
Witness, yes or no, do you live on the disputed land? Answer the question, please. Don't waste time of this arbitral panel.
No, I don't live on the land.
Thank you very much, witness. So you just cultivate the land, is that correct? You just cultivate the land openly, is that correct?
Yes, it's correct.
Yes, thank you very much. Okay, witness, you also said that on your statement on oath that you have not received any interference or encumbrances from people. Is that correct? Or from people, is that correct? You've not received any, let me come again, witness. You said that you've not received any disturbances from people since you've started cultivating the land. Is that correct?
If I got you correctly, you're asking if I was disturbed when I was cultivating the land, right?
Yes, exactly.
No, I've never been disturbed.
Okay, fine.
Witness.
Thank you very much. Next question, witness. Now, the land you are occupying, did you buy that land?
Okay, I earlier stated.
Yes or no, witness? The question is very clear. Did you or did you not buy the land? Yes or no?
My use of the land came as virtue of.
Yeah, witness, did you buy the land? Yes or no? Did you buy?
Objection, my lord. Objection.
I asked a simple question, yes or no.
Witness, you've been asked a question,
Objection,
right?
Mr. Chairman.
Hold on, Mr. Chisholm. Ogenetega has asked the witness a question. It's a direct question. It's a closed question. He asked the witness if he bought the land, right? It's I'm not sure there is any. Right. So just answer the question. Did you buy the land? Yes or no?
No, I did not buy the land.
Thank you very much, witness. So you did not buy that land. Thank you very much. Noted. Okay. What other thing should I have? Mr. Abjuto, there will be no further questions.
Thank you.
Thank you. Yeah. Any re-examination? Chisom, can you hear me? The defendants, I want to take it that there's no re-examination. Can we proceed then?
It's possible that they can't hear us.
I'm guessing so.
I've asked on the chat. Any re-examination team, Emerald?
Mr. Chairman, there's no examination.
Okay.
All right. Thank you. So this is your last witness, right?
Yes, he is.
Okay. So we'll proceed to adoption of final written addresses. Did any of you file your final addresses?
Yes, we did.
Okay, that's the
respondent. We did.
The claimant.
Yes,
did you? Okay. So what we'll do is, like in the first round, we'll take the claimant first. You will adopt your final written address, and then you speak to it within the timeline already specified. Right? So you adopt and then you speak to your final written address as quickly as possible so that we can make progress. Is that okay? The claimant will start, then the respondents will take over.
Mr. Abjuto, can I proceed?
Yes, please.
Okay, thank you very much, Mr. Abjuto. Mr. Abjuto, we found our written address on the 18th day of July, 2023, and contained in our written address are issues for determination, issues precisely on page 4 of our processes, of our written address, page 4. 2 issues are canvassed. First issue is whether or not Mr. Adewale's claim for adverse possession can succeed. And also the second issue is whether or not the claim of easement by Mr. Adewale can succeed. Mr. Abjuto, we filed also an argument from page 4 to page 7 of our written address, and also the reliefs and prayers sought, Mr. Address. And I'll proceed, and I'll be taking the first issue. I'll be handling the first issue for 7 minutes, and my colleague will be handling the rest for the remaining minutes, which is 8 minutes, a total of 15 minutes. Thank you, Mr. Abjuto. I'll proceed to the first issue, which is whether or not Mr. Adewale's claim for adverse possession can succeed. Mr. Abjuto, I'll be relying first of all, I'll be arguing in the affirmative, in the negative rather, that Mr. Adewale's claim for adverse possession cannot succeed. And I'll be basing my argument on 2 standpoints. One, which is that Mr. Adewale has knowledge that the land belongs to someone else, and thus his claim for adverse possession should fail. And also on my second standpoint is that Mr. Eniola has possession over the land, and thus the claim there is no issue of adverse possession. Onto my first standpoint, Mr. Arbitrator, which is that Mr. Adewale has knowledge that the land belongs to someone else, and thus his claim for adverse possession should fail. Mr. Arbitrator, it is a settled position of the law, that where a person who is bringing up a claim for adverse possession is aware that the land is occupying belongs to someone else, his claim for adverse possession cannot succeed. Mr. Arbitrator, this has been given judicial blessing in the case of Rains and Buxton and Bills and Kestin Bay Holiday Camp. Mr. Arbitrator, the citations of these judicial authorities has been duly cited in our written address. Mr. Arbitrator, moving on and applying this principle to this case at hand, Mr. Adewale is very much aware that the land in question, the disputed land, belongs to someone else. Mr. Arbitrator, during the cross-examination, he admitted openly that Mr. Eniola is the registered deed owner of the land, of the disputed land, and thus he knows that the land in question belongs to someone else. Also, Mr. Arbitrator, the defendant clearly stated that he has not had any disturbances from any of its previous owners. Mr. Arbitrator, this singular assertion proves that Mr. Adewale is very much aware that the land he is allegedly occupying, does not belong to him. It belongs to other people, it does not belong to him, and thus his claim for adverse possession cannot succeed before this arbitral tribunal, Mr. Arbitrator. Also, on my second standpoint, which is that Mr. Eniola has possession over this land, and thus there's no issue of adverse possession. Mr. Arbitrator, it is a settled position of the law that where a person who has title over the land is being challenged by someone else who is claiming, bringing up a claim for adverse possession, that claim for adverse possession cannot succeed because, Mr. Arbitrator, two persons cannot be in possession of the land. Two persons cannot be in possession of the land. Mr. Arbitrator, gleaning from the facts of this case and gleaning from our statement of fact, Mr. Ajayi is the registered deed owner of the disputed land. Thus, he has possessory rights over this land. He has possession over this land, and thus the defendant's claim for adverse possession cannot succeed because Mr. Eniola, who is the claimant, has possession over this land. And relying on this, I submit on this issue that Mr. Adewale's claim for adverse possession cannot succeed because one, is aware that the land belongs to someone else, and two, that Mr. Eniola, who is the claimant, has possessory rights over this land. And I will now defer proceedings to my co-counsel to handle the second issue. Thank you very much, Mr. Arbitrator.
Thank you very much, Mr. Arbitrator. I'll be commenting on issue 2, which states whether or not the claim of easement by Mr. Adewale can succeed, to which I vehemently plead on the negative. Mr. Arbitrator, it's first pertinent to establish what an easement means. An easement basically means an interest in land owned by one person, consisting of the right to use or control that particular land or an area above or below it for a specific period of time. Mr. Arbitrator, the land that benefits from this easement is known as the dominant tenement, while the land that is burdened by this particular easement is known as the servant tenement. Mr. Arbitrator, in the case of Olusoya and Oshineye, the court stated that an easement is basically when a particular person has a land and another party seeks to derive a benefit from that particular land. It further stated that the court further stated that for an easement to succeed, there must be an owner of that, there must be a particular person owning that particular land, and also another party who seeks to derive a benefit from that land. Based on this, submissions on this issue will be based on 2 major standpoints. 1, that the footpath is not an issue and not even an easement, and 2, that there is no dominant nor servant tenement. Mr. Arbitrator, on my first standpoint, which is that the footpath is not an issue and not even an easement, the position of the law is very clear on this. That for there to be an easement, as earlier stated and established in the case of Olusoya and Oshineye, that for there to be an easement, the particular land in dispute or the area in dispute must belong to one party, Mr. Arbitrator, and there must also be another party, though not being the owner of that property, but seeking or desiring to confer or to benefit a particular right from that area or from that land which is a dispute. However, Mr. Arbitrator, in this particular case, it can be clearly seen that this particular footpath, which is a contention by the respondents for easement, does not belong to either of the parties to this. And even during the cross-examination of the witness, and particularly Mr. Adewale, he clearly stated that no one owns the footpath, Mr. Arbitrator. He stated blatantly, to the hearing of this arbitral panel that no one owns the footpath, and thus this does not satisfy the requirement for there to be a claim of easement, as stated in the case of Olusoya and Oshineye, stating that the particular area of land in contention must belong to one party, and there must be another party. There must be another party seeking to derive a benefit from that particular land. Moving on to my second standpoint, which is that there's no dominant nor servant tenement. It is notary law that when an easement is, when a claim of easement is brought before any arbitral panel or any court, there must be a dominant and a servant tenement. This was established in the case of Munias and Ashafa. Furthermore, in that particular case, Mr. Arbitrator, the court gave out some conditions, some requested conditions for a claim of easement to succeed. One of them being that there must be a dominant and a servant tenement. A dominant tenement meaning the land that benefits from that particular easement, and the servant tenement being the land that is burdened by that servant tenement. However, Mr. Arbitrator, it is clear from the statement of fact that we cannot establish who the dominant nor who the servant tenement is. Why, Mr. Arbitrator? Because this particular footpath does not belong to either Mr. Eniola, who is the claimant in this case, neither does it belong to Mr. Adewale, who is the respondent in this case. And therefore, there is no dominant nor servant tenement, because this particular footpath in contention by the respondent has no is not assigned to any of the parties to this particular suit, being Mr. Eniola and Mr. Adewale, respectively. Mr. Arbitrator, premised on this authorities earlier stated, it is hereby submitted that the claim of easement by Mr. Adewale cannot succeed, Mr. Arbitrator. It can definitely not succeed. Why? Because, first of all, the footpath is not an issue and cannot be seen as an easement, because the particular footpath does not belong to either Mr. Adewale nor Mr. Eniola. And also, we cannot establish who the dominant or servant tenement is. And counsel prays that this arbitral panel holds same with the claimant and grants award in favor of the claimant being Mr. Eniola. Thank you, Mr. Arbitrator. We also wish to adopt our prayers and relief sought, particularly in our statement of claim dated and filed the 18th of July 2023. And our we seek for the following relief. One, that a declaration that the claimant is the rightful owner of the disputed land. Two,
okay. Thank you, claimants, for. I mean, you worked with time, and we appreciate that. So the defendants, are you ready?
Yes, you're ready.
All right. Again, adopt your address, identify your address, adopt this, and then you make your address.
Okay, thank you, Mr. Chairman. Mr. Chairman, in support of our point of defense is a written address dated and filed on the 20th day of July 2023. Mr. Chairman, we wish to adopt this written address as our point of argument in this trial. Okay, Mr. Chairman, in this written address, we have distilled two salient issues for determination. And one of the issues for determination is whether or not Mr. Adewale has acquired ownership of the disputed land by virtue of the doctrine of adverse possession. The second issue for determination is whether or not the claim of easement by Mr. Adewale can succeed. My Lord, I'll take on the first issue while my co-counsel takes on the second issue. So on the first issue proper, that is whether or not Mr. Adewale has acquired title to the disputed land by virtue of adverse possession. My Lord, it is our humble submission on the humble submission of the respondent that he has obtained or has acquired title to the disputed land by virtue of adverse possession. We're going to first of all define what adverse possession is. But before that, it was clearly stated in the popular case of Indudo versus Kumaba that a claim of ownership can be established by acts of long possession and enjoyment of land. That is adverse possession. I would like to draw the mind of tribunal to the fact that the respondent has been in possession of this land for a period of over 20 years. We'll get back to that, my Lord, Mr. Chairman. But adverse possession by a defendant is one in which derogates and is inconsistent with ownership title of a person who claims to be the owner of the land. Yes, but however, still go back to the provision, the case of Eduna where it was established as one of the modes of acquiring possession to a land. But our issue, this first issue is argued on 3 grounds. One is long possession of the land by Mr. Adewale is proof of ownership. 2, the statute of limitation of Lagos State operates against the claim of Mr. Ajayi or any previous owner. 3, knowledge on the part of the respondent that there is a previous owner or of any land does not affect or defeat the principle of adverse possession. I'll take on the first ground of our argument. It is clear and established, as just like in the case of Inu Kumaba, in the Legushi versus Oseni, that one of the ways of establishing title to land is by acts of long possession and the enjoyment of land, especially where it can be shown that a party in possession of the piece of land in dispute have been in positive and constructive possession of that land for a very long period of time and have made development thereon. And, Mr. Chairman, I wish to remind you of what I mentioned earlier, that the respondent has enjoyed total and complete dominance and control of that land for over the past 20 years. Now, this falls within the definition given in the powerful case of Edinu Kumaba and also in Elegushi versus Oseni. But going further, it is now a notorious position of law. In fact, it's no longer notorious, it's now a judicially noticed position of the law that possession is 9 terms of ownership. That means that where a person is found to be in possession of a land, it thereby establishes a presumption that that person is the owner of that land until the contrary is proven by another person laying claim to possession of that land. And in the first of the case, it was clearly established, like I said earlier, that the respondent has the title to the land and has continuously occupied and cultivated the land openly, peacefully, and without interference from Mr. Eniola or any previous owner or his predecessors in title. Well, this corroborates the affirmation of the claimant, Mr. Eniola, in paragraph 2 of his statement of claim to the effect that Mr. Adewale owns the disputed land which is adjacent to the claimant. But that affirmation in his statement of claim is a prima facie admission to the fact that the disputed land belongs to Mr. Adewale. It is shocking to us that this action was there in the first place to lay a claim to the disputed land belonging to Mr. Adewale after the claimant had admitted himself, admitted in writing that the disputed land belongs to Mr. Adewale. We are shocked, and this is a very disturbing finding. Mr. Chairman, it's also reviewed in paragraph 3 and 6 of the respondent witness 2 statements on oath that both the claimant has been in possession of the land adjacent to the disputed land, and Mr. Adewale has been in possession of the disputed land. I want to draw the mind of Mr. Chairman to the fact that the respondent witness 2 is the claimant's vendor, that is the claimant's predecessor in title. Hence, the respondent witness 2 is deemed to have full knowledge and absolute knowledge of who belongs to, who has been in possession of both the disputed land and the adjoining land. And he clearly stated in his statement on oath that he assigned the land adjacent to the disputed land, that is the land today number 10, he assigned it to the claimant while the disputed land has been in possession of the respondent even before he assigned that adjacent land to the claimant. My Lord, this is clear and first-hand evidence coming from the respondent witness 2, that is Mr. Ajayi. He serves as a strong witness in this case. My Lord, the respondent has also been in possession of the disputed land even before, like I said, even before the claimant acquired title to the land. That is the land which the claimant admitted both in his claims and that number 10 belongs to him, and the land in dispute, that is the one disputed number 2, belongs to the respondent. Consequently, the consistent possession of disputed land is to be deemed a substantial proof of his title to the land. But my Lord, a very interesting part of this written address, a very interesting part. Now, that our ground of argument is that the statute of limitation, I want to establish that the statute of limitation embodies the doctrine of adverse possession. Now, the general principle as regards statute of limitation is that wherever there is a time window for instituting an action, whenever there is a time window for bringing a cause of action, that action must be brought within that time window in order for that action to be competent. Else, that action will be said to be statute barred. This is clear. This is a very popular and notorious position of the law in the case of Obiefuna versus Okoye. This is a case which we have thrown about, and this principle is as strong as it gets. My Lord, it is also provided in the same limitation law of Lagos State that no action will be brought after the expiration of 12 years from the date on which the right of action accrued to the person bringing it, in this case, the claimant, or if it is first accrued to some person through whom there are claims to that person. Now, assuming we're not considering that the claimant has title to this land, and he claimed to have acquired the land by 2005, and he's bringing this claim 18 years after he ought to have brought this action. This shows a lot. This goes to affirm the provision of that section 16 sub 3A. This goes to contravene the provision of that section 16 sub 3A, which provides that we ought to have brought that action within a period of 12 years. So that means having brought this action after 18 years of the accrual of the purported adverse possession, which he is claiming, on the purported adverse possession, which is claiming that right of action is statuted by the provision of that 16 sub 3A, because he brought that action outside the time window provided by the limitation law of Lagos. In fact, it can be gleaned from paragraph 3 of the claimant statement of claim and paragraph 3 and 6 of the respondent with this 1 and 2 statement on oath, respectively, that the respondent has been in undisturbed possession of the disputed land for over 20 years. Mr. Sean, please take notice of this. Now, in addition, Section 17 of the limitation law of Lagos State is to the effect that where the person bringing an action to recover land has been in possession thereof and is entitled to bring an action by virtue of that land where he has been dispossessed of that land, that right of action will be deemed to have accrued on the date of dispossession. Now, what does it mean? It means that from the time Mr. Adewale, from the time the respondent, that is Mr. Adewale, came into contact with that land or took possession of that land, that the claimant, that is Mr. Eniola, who is claiming that land belongs to him, he ought to have brought his action. The time we know for that action started accruing from the time when Mr. Adewale came in contact with that land. And from that time till this time, when he brought this action, is over 18 years later. So that means that the time window for bringing that action had expired, even though it's accrued. And this was assuming, but not considering that the land even belongs to him in the first place. But now, the claimant's action for recovery of the disputed land in the statute bad, having brought this action after 20 years of the adverse possession of the disputed land by the respondent. This is because the claim was not brought within the time window provided in the limitation law. Then, to nail the coffin, Section 21 of that limitation law of Lagos State provided that on the expiration of the period fixed by law for any person to bring an action to recover land, the title of that person to the land will be extinguished. The claimant's action for recovery of land was brought 20 years after an accrual of a right of action, as gleaned from both the facts of the case and from the various statements of oath and from the statement of claim. So that means that his statute bar to bring that action and his right of action has expired and has been extinguished. This thereby means that that land, by virtue of adverse possession, has passed to Mr. Adewale, that is being the claimant. Sorry, being the respondent. Now, the third ground of our argument is that knowledge on the part of the respondent that there is a previous owner of the disputed land does not affect or defeat the principle of adverse possession. From close perusal of the various limitation law, from close perusal of the various principles of adverse possession, which we have done due research on and which has been established by law. Mr. Chairman, there is no provision for knowledge as an element to extinguish the plea of adverse possession. There is no provision, there is no statutory provision, there is no case law provision to extinguish, to establish that knowledge is an element for proving adverse possession or for defeating the plea in the first place. Now, even the claimant in the statement of claim grossly and wrongly cited the wrong authority in paragraph 3.1.4 of the statement of claim. Now, it cited section 14 of the law of Lagos State as a section, as a purported section which provides for knowledge as an element for proving adverse possession or for defeating the plea of adverse possession. Mr. Chairman, that section provided that the right of action to recover land shall not accrue unless there's adverse possession. Now, assume we're not considering that title to belong to Mr. Eniola, the claimant in the first place. His right of action, like I mentioned earlier, started accruing from the time of Mr. Adewale's adverse possession. But now he stepped on his right and did not take or did not activate that right of action. Now, from the gamut of this case, it is evident that the right of action accrued from the respondent's adverse possession, but same was extinguished by virtue of limitation law. The case law was submitted by the claimant to prove knowledge as an element of adverse possession also comes short of defeating the plea of adverse possession. My lord, in the cross-examination of Mr. Eniola, that is the claimant witness 2, he admitted that the land situated at number the land situated adjacent to the disputed land belongs to him, that is the claimant. So that means that there are 2 lands in question. Now, one land belonging to the claimant and the disputed land belonging to Mr. Adewale. Now, even both on his written depositions and on his on the cross-examination, and also in paragraph 2 of his of the pleadings of the written statement of the written statement of oath, and also in paragraph 2 of the statement of claim, he has admitted, he has made an admission that his own land, as assigned to him by Mr. Ajayi, was the land adjacent to the disputed land. An admission before the tribunal is prima facie evidence as to the facts in issue. It's a prima facie evidence as to the disputed facts, and he has admitted to the fact that he has no connection to the disputed land, that is the land belonging to Mr. Adewale. Now, too, he also admitted, that is the CW2, Mr. Eniola, the claimant in this dispute. He admitted that number 12 Peshwe belongs to Mr. Adewale. That was when he was cross-examined as a witness. Now, also, he also admitted that the land sold to him, that is the land he has title to, was the land located at number 12. This land located at number 12 is the land which is adjacent to the disputed land, which has admitted belonged to who? To Mr. Adewale. So, Mr. Chairman, from the whole facts of the case, it has established that the respondent has a strong case for adverse possession, and that land in dispute belongs to him. Now, I'll allow the second my co-counsel to take on the second issue now.
With which time now?
You have 15 seconds only. Whatever I can say in 15 seconds.
Wow. On the issue, the issue of is, I don't know if you would allow me for a little extension, but on the issue of easement.
But your time is up now. Your time is up. I mean, there's nothing we can do right now. If you are already on it, we could have said, okay, let's extend time. But now we can't give you 2 minutes or 3 minutes. I mean, it will be cheating the other.
I will summarize it only 2 minutes, actually.
Unfortunately, I was watching the time when your partner was speaking, because he started by saying, "I will take the first issue, and my partner will take the second."
Yeah, I will actually summarize.
I wanted to interrupt him to ask, are you sure? Are you taking everything, or is your colleague still going to take the second issue? You know.
Unfortunately, you've been shut out. You've been shut out.
Yeah.
So
sorry.
Because this is a competition. If it was an actual trial, we say in the interest of justice, let us hear you. Because this is a competition, and then timing is
in the interest of justice.
We will insist on the time, and then thank you for your address, right? So this brings us to the end of this particular proceeding. I think we will now, as a panel, hand over to the moderator to tell us where we go from here.
Okay. Thank you so much. Thank you so much, our wonderful arbitral panel. Thank you, Mr. Chairman. Thank you, the other arbitrators, Mr. Chimezie, Mr. Daniel. Thank you so much. Thank you for your time. We've been here since 11. That's quite a stretch. And I must commend the students. I think I was impressed with, to an extent, with the game that this second team brought. I mean, I was impressed with the game. In as much as, yes, there were a lot of, the fact that you were observant is something that it's commendable. you made, I think I would say you learned more because you looked through things, as in you paid attention to details. So I would want the judges to just make one or two comments. Then, but there's something before the judges make their comments. This is with respect to your processes. Remember, one of the purposes of this competition is to help you learn how it is done in practice. Now, I can't remember the particular team right now. In your process, when you're making a denial, it's usually advised as you make a denial, don't just stop at that denial. Respond, make an averment in addition to the denial. Do not just stop at denial. And then one of the teams, in as much as it's not very compulsory, but when
sorry to interrupt you. Please, are we sure all the teams are here so that we don't have to repeat ourselves? The first two, are they still on the call?
I think one of them is here. I don't know if Tim Beryl is here. Okay, Tim Beryl is here. Tim Beryl is Ewoluwa, right? Ewoluwa, you're Tim Beryl.
Yes. Yes. So it's Tim Diamond here.
And then Emanuela is Tim Diamond. So they are here. They are representative. Okay. Okay. So I would want then also respect to our processes. It's usually also advisable in practice when you make a that's for the defendants particularly. There was one team, I don't want to mention the team, that did not have a counterclaim. Oh, that was a bit lazy. The court is not a Father Christmas. The court, or even arbitral panel, whatever, it will not give you what you did not ask for. So it's usually encouraged most times. Once it's usually encouraged to have that counterclaim. I think that's what I want to talk about. I know that the judges will talk about the arbitration, the hearing, and the arbitration moots proper when they are giving their comments. I think this is this. So, Mr. Chimezie, Mr. Kigai, Mr. Daniel, the floor is yours for your comments.
Okay, so let me take the first bite. First of all, I must commend all the teams on your performance and your presentation throughout the proceeding. Of course, I wish we had more time so that we can teach. Well, again, it's a competition. So we expect that when you go back in-house to your respective faculties, you, as much as possible, try to have like in-house, intra-chamber, inter-chamber, inter-faculty competitions that will now educate you on some of this, and so that when you come out to an inter-university competition like this one, you would have grabbed some of the rudiments that you need to learn. Now, to start with, Tim Beryl, who was the claimant, who were the claimants rather in the first trial, I noticed that during the adoption of your witness statement on oath, you really were not sure what you're doing, right? There was that. So initially, it was as if you're even taking oral evidence and not necessarily adopting your witness statement on oath. And even when you needed to adopt it, you did not lead the witness to adopt it. You basically said either we adopt or we tender, something like that. Again, let me remind you that although arbitration proceedings are not court proceedings, and so they are not as strict as court proceedings, but they also have procedures that you need to follow, right? And so, of course, I was on the lookout for all of this because, again, there's an expectation that you may not be conversant with the arbitration procedure, but you should be conversant with at least the basic procedure of leading the witness to adopt his witness statement on oath and then tendering evidence, how you should go about it. Right. So I think we should take note of that. Subsequent teams, when they were leading their own witnesses and then tendering evidence, perhaps because they had noted it from your own performance, they did better, especially the last two who just concluded their evidence now, they did better as far as adopting witness on oath is concerned and then tendering documents. Other than that, for the first team, I think you did fairly well. Well done to you guys. Again, we have made the point, but let me just emphasize that there are certain issues that were raised as objections, especially in the second trials, that just go to the issue of weight. So you reserve certain points, you reserve certain objections to your address, where you now comment to say, for instance, that because this document, because the witness even says this date in the document, referring to a particular document, let's say the date of assignment, and then this date of assignment mentions a different date, then there are two different documents. While it is acknowledged that that can be kind of a question of admissibility, right? But because arbitration panels are typically going to admit documents, provided they consider them to be relevant, because like we have mentioned, the Evidence Act does not apply. So what applies is rules of evidence, right? And generally, again, it's guided by relevance. So the tribunal may most likely admit the document. So you reserve some of these points to your final address to say you can't rely on this certificate of occupancy because there is discrepancy in the dates, or it was not properly certified, or the surveyor who issued it is not properly qualified. All of these points are issues that you can use to address or to discredit the piece of evidence that has been tendered. I also noticed that during your cross-examination, especially the first trial, there are points, and I thank God I was muted. I was just whispering to myself, why are you asking this question? Why are you asking this question? I think you need to do a lot more work on learning how to cross-examine. Again, I need to point out that cross-examination is a lifelong journey. Everybody keeps learning, no matter how long you've been practicing, right? But it's something that you can learn. So questions that somebody was asking, how are you sure she saw when the notice about the stop work notice, how are you sure she saw the notice? Or these are opening a lot of doors for the person to give you answers that you don't want, right? You can leave it at the fact that the person has not seen it or something. You need to learn about cross-examination. I quickly or easily refer people to, I think you'll find it on YouTube. There's a video by Professor, I think it's Irving or so, the 10 Commandments of Cross-Examination. You can find it on YouTube. That's always a very reliable tool to learn about cross-examination that I highly recommend to anyone. So I'll get the name on YouTube and then post it on the group so everybody can go and check it out. Know what to ask during cross-examination is very key, very material. I start learning from now, because you do not know what will happen after. Your first appearance in court may be for you to conduct trial, so you don't have time to learn when you're in practice. Start learning from now. These opportunities are avenues for you to learn and develop to hone your skills in cross-examination. Then another issue I had was with the re-examination. I think almost everybody had this issue. Almost everybody who asked the examination question was just taking another bite at the cherry. Re-examination is to clear ambiguities, even in arbitration. So there's no open window to just ask any question that comes to your head, or because you feel that the damage was done to your case, you want to repair it during re-examination. We allowed it because we didn't want to give any hint to the next person coming, but please note, re-examination is to clear ambiguities and ambiguities alone. So if there is no ambiguity, there is no need for you to begin to ask questions. A judge or an arbitral tribunal will not allow it subsequently, right? And again, it now shows that you're not very good at your craft. So tailor your questions in re-examination to clearing ambiguities that have arisen. I say again, none of the re-examination questions asked today in the two proceedings was relevant. They were all just everybody trying to have another bite again at the cherry, right? So it's better to say I don't have any question at all than to attempt to open up your examination in chief again, right? So let me allow we spent the entire day. Let me allow the other arbitrators to have a bite, and then let's wrap up. Thank you. But again, I must say well done. I must say well done. This is the first one for you guys, so you guys have done well. Just note the comments we have made for subsequent proceeding. Well done.
Chimeze, do you want to go first or do I go ahead?
Okay, so let me just proceed. I think Kigai has pretty much hit the nail on the head with respect to most of the points that I noted down whilst the teams were making their presentations and arguing their respective cases. So I first of all, I just want to commend all participating teams. You all did very well, very well, at least for students of your level. I mean, I'm very impressed. I must commend you all. You would leave here with your heads held very high, that you did a very good job. I'm very impressed with, I was very impressed by your arguments and the way you did. It means that you put in a lot of work into this. So kudos to you all. Just to make some points. Okay, one with respect to the opening address, right? So let's assume that we're all lawyers. Of course, you must not be a lawyer for you to. Arbitration is not litigation. So, because on the assumption you are all aspirants to the bar, right? In the opening address, it would appear that a particular team was reading directly from, something that they had put down, right? So it wasn't flowing, right? So you should be able to know your case. You should be able to put out your points in a very coordinated manner. You should be able to, pass across your arguments very clearly, right? You don't need to read from a document. We already have your document. If we wanted someone to come and read from the document, we just say, don't worry, we'll read your documents, right? And then again, this is for the team burial, right? The first team. I realized that during the opening statement, the first team did not do enough, right? The opening statement is not about telling the tribunal, reading your documents, telling the tribunal what your case is all about, right? It goes far beyond that as well. Now, it's an opportunity for you, first of all, to summarize your case, tell the tribunal what your case is all about, and then also tell the tribunal, let the tribunal understand what you intend, the points you intend to establish in the case, and how you intend to establish these points, right? So it's the opening statement actually directs the tribunal to it's some sort of a direction to let the tribunal know that this is where you are headed, right? It's a roadmap. It's not just for you to say, these are my claims. These are my claims, right? I intend to call so and so witness at the hearing. I intend to prove that this and this and this happened, and this is how it's supposed to be. At the end of the hearing, would have proven to this tribunal that this and this and these are the exhibits that we intend to use to prove. So those are the things you try to summarize your case, let the tribunal know how you intend to establish your case, and then it directs us to have our minds in that area so that when you start to address us post-hearing, we actually know that, yes, you've made these points, and then these are the points that areas we should be looking out for. Team Burial didn't do that, but I noticed that Team Diamond did that. That was their opening address was top notch for me, right? Again, Kigai has already made the point with respect to adoption of witness statements, so I don't need to go into all that. Some of the team members could not properly adopt the statements, while others did well in that regard. And then he has equally made the point about cross-examination, right? Just to re-echo what he said, you don't leave the witness, you don't, first of all, in cross-examination, you don't ask the witness questions that you do not know the answer to, that you do not already know the answer to, right? And secondly, you do not give the witness the opportunity to explain. You do not give the witness opportunity to deflect, right? You ask closed questions, yes or no, that would require yes or no answers. And then I realized that it was only one thing that quite impressed me during cross-examination, right? I think that was, hold on. Hold on, sorry.
Was that the cross-examination of
Yes,
Emmanuel
Tega.
Okoro?
Yeah, that was
yeah, cross-examination of Emmanuel Okoro.
Yes, he
Yes.
was
Simple.
yes, yes.
Ended questions.
Yes, he
Yes,
was very direct with his questions. He already knew what he wanted. You know, he didn't give the witness the opportunity to deflect, to start explaining, you know, things. Just answer me yes or no. These are yes or no questions, right? So I thought to also make that point as well. Again, I must also commend the Pearl and Diamond team on their final addresses, right? The delivery was top notch. As a matter of fact, Darlington forgot that he should be working with time. And then he took the time to the entire time, even the time of his teammates. He didn't allow his teammate to shine. So I must commend you all. You did very well. You did very well. And unfortunately, it's a competition. There must be, you know, a winner. But even if you don't come out victorious, I mean, it doesn't change anything. It doesn't take away the fact that you all are all shining stars, and you did exceptionally well. And I know it's going to be a very difficult situation determining who, you know, did better, right? So yes, I commend you all. I also encourage you all to continue to be engaged in, you know, competitions like this. It pushes you to work hard, to learn, and to be involved in the process. Thank you very much.
Thank you. Such amazing.
So I will just Chimeze and Mr. Kigai have addressed most of what I have in my notes. So, just for sake of emphasis, they've already said a lot about examination in chief. You have statement, just adopt it. It's very straightforward. Cross-examination, I would just to reemphasize, Chimeze mentioned, don't ask questions you don't have answers to, and don't have questions that you don't have comebacks to adverse answers. What I mean is, if I'm answering and what you're saying is yes, if that works for me, if you say no, I should have calculated what I should do or what I intend to, how I intend to go about it. Avoid verbal tics. So the witness tells you, yes, and you say, oh, great. Exactly. You're giving a cue as to, you're giving a cue as to what is damaging or what is not damaging. They begin to read your tone. So keep your front solid, whatever answer works for you. And it's especially, it was important for me that, it was worthy of note that you had documents you could show to the witness. So if you ask a question and the witness said no, simply tell the witness, look at this, do you still stick? Like when we're dragging, there was a particular person who was dragging a witness statement, and I did not see why you were dragging that witness statement. Questions you should have asked, you should ask the question, the witness, do you still, is this your witness statement? Did you depose to it? If you already found out that that witness statement works for your case, simply just make him reaffirm that, and end it. You necessarily must not begin to drag him, and you had points for where you were supposed to object, you didn't object. Points where you're not supposed to object, that was where you were not objecting. So you should know what is damaging and what is not, what to focus on and what to not focus. You allowed the other guy lead his witness to say, oh, this is the error, what I want to correct, this is what I'm not correcting it. Then meanwhile, for things that you're supposed to let slide, you were heavy on it. So know what points exactly to drag. I must repeat that all of you did very well. I was really impressed. I won't lie. You know, I heard you guys arguing, and I was asking myself if I could make this argument while I was in university. I kid you not. You guys, no, you guys did well. Honestly. Now, for the cases, so the scenario is such that the favored our ex. The scenario is such that the first one, for instance, favored the claimant a lot. If I was in the claimant team by the scenario itself, I'll be happy. So, but it was beautiful to see the defendant give a fight for it. Because for me, it's simple. I have a contract with you. These other people you're bringing into, I'll just simply raise a defense with privity. It's not. I don't have any business with those people. It is you I have a contract with. You gave me allotment, and you have failed. So the case really favored the claimant. So it was beautiful to see the respondent fight back. I must commend the respondents in the first scenario. The guy also talked about opening statement. So for me, no, that was Chimize talked about opening statement. Now for opening statements, I will just give a point or two on that. Every case, you rise and fall with your case theory. So if you have a case theory, for instance, and what your case theory is that this phone that is black is white. What you are trying to establish from your opening statement, from the get-go, is to tell the tribunal that indeed this is white, and these are the features of white, and this is why you're calling the tribunal to do this. In the course of this trial, you show the tribunal why, although this seems white, this seems black, this is going to be white. So you give, it's like a teaser for the tribunal. You begin to explain your side of the story to the tribunal. Let the tribunal begin to anticipate what you are going to lead in evidence and how you are going to prove this. That's really what an opening statement is. It's an opportunity for you to sell your case theory to the tribunal. You give it to the tribunal and they're like, okay, begin to get a sense of, don't forget, they've read your processes, right? So what you're doing with your opening statement is to begin to have their mind, around where you want it to be. So when you begin to lead evidence, it's easier. At the close of your statement, so opening statement is like, I'm telling you what I'm about to do. In evidence, I'm going to do it. Closing statement, this is what I said I was going to do, and I have done it. And that is why I want you to agree with me. In layman terms, you put it as simple as that. You get the hack of it. Usually, the issue of case theory, why I say guys your entire case, for we where I work in my firm, we start with our processes backwards. So if I have a case theory, what I do is I have a draft of my final address, indeed, before I do cross-examination. So I said, this is what my case theory is. I go to my final address. I don't draft the entire address. I leave spaces for where evidence, but I know what I am looking for. So what that does is it affects the kind of questions and what I'm looking for to achieve in my cross-examination. So I leave out irrelevancies. There are things you surely need. Anything that doesn't flow into your case theory, that doesn't help achieve that case theory, don't fight it. Having a case, it helps you frame your mind around what you want. So somebody feels like the contract in your case, you are calm because it doesn't affect what you want to achieve or what you're trying to push for the tribunal. I'm just saying, this will just help. What I'm talking about more flows from pre-trial to trial, but it still affects the entirety of what happened today. So cross-examination, examination in chief has been talked about. I just talked about opening statement and closing statement and how that is important. I didn't expect you to have the procedure for arbitration 100%. We expected that you would most likely approach the procedure like a normal court procedure, but they are quite different. But some things are different. The reason they say they are quite different is because, well, Evidence Act is not there. A lot of things are not involved. But in terms of how it operates, really, you must have an idea as a lawyer. You must have an idea around how, for instance, we talked about adoption of witness statement. Even though nobody's going to flog you, but there's a way it should be done, and you should do it that way. And then for exhibits, your normal court procedure, when you bring documents, it depends on how you what procedure you're coming in. Do you label document exhibits before they are tendered? Or do you just drop the document? So in arbitral proceedings, you can simply come to the tribunal and say, this is the document you want to rely on. You must not label them exhibits. In court as well, if you're coming through a witness statement, you don't label them exhibits. You don't decide now, because there are going to be objections on those documents that the court, I'm talking about now litigation, whether the court is going to admit or not, and all of that. So you just simply come, especially when you're tendering those documents through a witness, you don't label them exhibits before you bring them before the court to tender. I don't know if you get if you appreciate that. So you bring your document, is what I seek to tender. The court now admits and says, oh, this label this exhibit this. I'm just saying in terms of litigation. For arbitration, you can honestly just come with your document and tell the tribunal that these are the documents that you intend to rely on, and name your documents without going through the laborious process of marking them yourself as exhibits. Anyways, as you guys said from the beginning, if we had the chance, we would have done a bit of a teaching around this, because I honestly would have to stop now and then allow the moderator to continue. So thank you all very much. I commend you for your hard work. Honestly, commend you for your hard work, I must say. It's not going to be easy to decide. You guys did very well. Congratulations to all the teams.
Hey, thank you, Mr. Daniel. Thank you to our participants. Like I said, and the arbitral panelists have also said the same thing. You guys did well. You guys did well. We are really going to have little difficulty determining the winners, but you all put in you put your best foot forward. But it's just, it's a competition, and we just have to have our finalists. So very soon you'll be communicated the date, as in that's the qualifiers for the finals. So the finals will be a litigation round, and we're going to have practicing members of the bench as the judges. This is why you need to really take note of these things that they've said, because it's going to be another, it's going to be a very, it's going to be, that the winner would be the person that really went the extra mile, because now it's amongst teams that are good. You all are good. So the winner will now be someone that just did something extra to emerge. So once again, I appreciate every participant, Team Beryl, Team Diamond, Team Emerald, Team Pearl. Thank you all. Thank you all. You would hear before next Thursday, the qualifiers for the finals. The finals should be on the 10th of August, Thursday, the 10th of August, 2023. Thank you once again to our judges for staying. This was a whole day something, and we really appreciate their time and efforts and their input. Thank you, Daniel. He's part of an election petition tribunal, and I know how that thing can be very demanding. Thank you, Kigai. From your busy schedule, you really made out time to be here. I really thank you, Barrister Chimezie. Thank you so much. These are very busy lawyers, and this is voluntary. This is something that you're just doing to help legal education. So I really appreciate you all. Thank you, thank you, thank you, thank you. So we are going to see that for the teams that will make it to the finals. We'll meet at the finals. Thank you. At this point, I would want to draw the curtain on the semifinals for the Honorable Justice Innocent Umezilike Foundation National Moot Court Competition 2023. Bye. And
all right, Ruth, well done. Daniel, Kigai, it was really very interesting and nice doing this with you guys. Enjoy the rest of your day.
Thank you very much.
Thank you, Timothy. Thank you, Daniel. Thank you, Ruth. Thank you.
It was nice meeting you. I met Kiga already, but Chimeze, thank you very much. You're really smart. When I had first class, you showed all of it.
You guys are smarter than me.
Oh, no, you're the Lagos lawyer.
Okay, the Lagos and the Abuja thing, I've started again.
All right.
Thank you.
Thank you all.
All right.
Yeah,
Have
thank
a
you.
pleasant evening.
Yeah, you too.
Bye. We can, okay.